Court, all rise, please. Hey, all persons having anything before the Honorable Justice of the Appeals Court, now sitting in Boston, far and within the Commonwealth. Draw near, give your attendance, and you shall be heard. Once in the Commonwealth of Massachusetts, this court is now open. Please be seated. Good morning, Your Honors.
Good morning. Good morning, and welcome to the April 3rd, 2025 sitting of the Massachusetts Appeals Court. My name is Catherine Hand. I'm joined on my right by Justice Marguerite Grant, on my left by Justice Chauncey Wood. We're your panel for today. We have 6 cases on. I expect that we will hear the first 3 cases and then take a break and continue back for the remaining 3. For those of you who have not been here before, I'll remind you that it's 15 minutes per side. I'd ask when you take the podium that you wait for the green light of the 3 lights that are in front of you to start before you begin speaking. The green light will go until you have a minute and a half left. Then the yellow light will come on. When the red light comes on, I would ask that you finish your sentence, and if we have additional questions for you, we'll continue from there, but otherwise, that will be the expiration of your time. There is no rebuttal in the appeals court. So, with that, our first case today is Commonwealth versus Morris I. Clemens, 2024 P1004. Good morning.
Good morning, and may it please the Court. Jesse Crane for the Commonwealth. The primary question for this case is whether Commonwealth v. Garcia applies given the motion judge's 3 factual findings on the motion to suppress. And those factual findings were that the defendant displayed indicia of impairment, that he was reaching towards a bag on the driver's side floor, and that the officers recognized a corner baggie in the defendant's truck.
Sorry, you said indicia of impairment. I'm confused. My recollection of the record, correct me if I'm wrong, is that he suspected that, the officer suspected that, had the defendant exit the vehicle, conducted field sobriety tests, and the defendant passed those field sobriety tests. And I think at that point, the officer said something to the effect of, I didn't have any basis to believe he was impaired at that point.
So I think on the actual order, on the written order, the initial order denying the defendant's motion to suppress, the judge did explicitly say he found that the defendant was displaying indicia of impairment. I would submit that the officer's testimony was slightly more equivocal. He did administer, I believe, 4 field sobriety tests, which the defendant did complete to his satisfaction. But when the motion judge asked him whether he formed an opinion as to whether the defendant was impaired, he said, no, I didn't form an opinion. I think at that stage, because the officer had just completed the field sobriety tests, and then his colleague, Sergeant Levesque, motioned him towards the truck to say, I just saw a corner baggie. My interpretation is essentially he hadn't formed an opinion one way or the other. Essentially, this was still an ongoing, I guess, investigation into the defendant's impairment.
What if the defendant said, this is a hypothetical, that he hadn't slept for a week, and the officer formed an opinion after he passed the field sobriety test, formed an opinion that he was not under the influence of anything? Could the defendant still be showing signs of impairment?
I think the defendant could still be showing signs of impairment, and I don't know that the officer necessarily needs to accept the defendant's explanation. Certainly, sleep deprivation could be consistent with the behavior that the defendant was displaying. He was obviously slumped over the steering wheel, the car was still in drive, the car rolled forward when the defendant was awoken. But I would submit that that's perhaps just as consistent with impairment as sleep deprivation.
What's a glassine bag?
I guess I would point to Garcia and the language that they use. I think they refer to it as a 1 by 1.5 inch plastic bag that's consistent with the distribution of illicit narcotics.
But, sorry.
Do you know if glassine is transparent?
I don't believe in Garcia they talk about that. The bag in this case was transparent. I believe that Officer Trudeau referred to it as a plastic translucent baggie. So in a sense, I think Garcia, maybe the bag in Garcia was potentially different than the bag here, which I think was described as translucent and made out of plastic as opposed to glassine.
What I'm struggling with is, so I'm trying to find my best record site, but a small, clear plastic bag, that's in quotes. There may have been more. But, so what I'm really trying to get at is, and in you described Garcia. In Garcia, we're talking about a 1 by 1.5 inch glassine bag, I think is what they said. How do we know this was not a Ziploc sandwich bag that my kid takes to school?
I don't think we necessarily do from the description, but I think what's important is that it needs to be viewed through the context of all of the officer's observations prior. I guess I'll note that the testifying officer, Officer Trudeau, did say that he had some training and experience in narcotics investigations and that he was familiar with how drugs are packaged.
But did he say that he understood the significance of the term corner bag? Because he's the only testifying officer, I believe.
That's correct. He is the only testifying officer, and he does not explicitly say, I understood the significance of the corner baggie. But I think in the context of his testimony overall, he says he's familiar with narcotics packaging. He says Sergeant Levesque and himself both refer to it as a corner baggie. He describes a translucent bag. I think it's a fair inference for the motion judge to make the finding that he did initially, that this was a corner baggie, with the implication that this is something that's maybe not in and of itself in a vacuum indicia of possession of narcotics, but in a broader context, I think the inference is certainly permissible and supported by the record.
So just so I'm clear, nobody actually seized this bag?
No, sorry, did you say seize or seized?
Seized, S-E-I. Is it in evidence? Is the bag in evidence?
It was not submitted as an exhibit at the motion hearing, no. I do believe the testimony was that Officer Trudeau reached into the truck, into the driver's side wheel well, I guess, or not wheel well, onto the driver's side seat and picked it up off the floor, which is then where he sees inside the canvas bag.
Right. But, yeah, okay, thank you. Thank you.
And I think the canvas bag is also a relevant factor in determining whether there's probable cause here, because it's not just that the defendant is displaying indicia of impairment. He also, when he is awoken, is asked for his license and registration, and he's struggling to find it. He first looks, I believe, in the glove compartment in a folder. He doesn't find it. He's searching for about a minute. And then he makes this kind of strange motion towards, like underneath the steering wheel, where he's reaching, the officer can't see what he's reaching for, and he's closing his legs and holding his arms together in a way that the officer believes he's trying to shield whatever it is he's reaching for. The officer asks him first to put his hands on the steering wheel, and then the defendant does not comply with that request.
Yeah, so I'm familiar with the facts. Your opponent makes what I think is a rational argument. I'd like to hear your response, that the officer says, can we please have your license? And so first of all, even though he's been asleep, he immediately starts looking for his license. He goes to the glove compartment, he goes to a folder on the passenger seat, and then, not finding it, goes to this something in a bag we figure out, and he's trying to find it. And then the officer says, put your hands where I can see them. And your opponent makes the rational point that, look, he's now got two contrary orders: find your license and put your hands where I can see them. The second being making it impossible to do that. Why is that the point I think your opponent's making is, how can that rationally be furtive? If also, he's just woken up, so maybe he's not so speedy. How is that a rational inference that he's being furtive?
I don't see them as necessarily contradictory orders. He was looking for his license first for, I think the testimony was 30 seconds to a minute. And then he reaches down, and I think it's reasonable at the stage where he's reaching down and hiding his hands for the officer to say, hold on, can you please put your hands where I can see them, because I can't see where you're reaching. I don't, and I think, you know, this wasn't a case where he reached down for a second and then immediately pulled them back up, and, you know, I think it's important that he's not just reaching down, allegedly trying to look for his license, he's actually hiding his movements. He's putting his legs together, he's moving his hands and arms together in a way that makes the officer, I think, understandably nervous, because he's shielding whatever he's reaching for. So I don't necessarily see that as, you know, the point is well taken that it could be interpreted as as two contradictory orders, but I think in the evolving nature of this stop, it was reasonable for the officer to become nervous and become suspicious because he's shielding what he's doing. He's not just reaching down, pulling the bag up, grabbing his license.
I just want to drill down on that in 1 second. I take your point and agree with your point that it's reasonable for the officer to become nervous. I get that. It's nighttime, he's there by himself. It's actually 2 against 1, but okay, he's mostly by himself. And he could be nervous, but that, I'm not sure I follow you, that, and therefore because the officer was reasonably nervous about these motions down, that therefore the defendant was doing something furtive. They're two separate things. The furtiveness is in the defendant's mind, and the reasonable concern is in the officer's mind. And I think we have to focus on whether the defendant was doing something furtive.
Well, I think the furtiveness is the kind of odd move, like the odd shielding motion with his legs and his arms and his hands. I mean, this isn't, I don't think the record is clear exactly how big the cab space is of this truck, but it's not clear that he was, you know, in a tight seat where he kind of needed to make an awkward motion. The officer is saying he's putting all of his limbs together in a strange way, rather than just kind of reaching in and maybe just pulling the bag up or just quickly reaching into the bag to grab his license. I think that's where the furtiveness comes from, is the defendant's motions with literally all of his limbs.
Well, your opponent makes a very specific and I think useful point that it's not a bench seat in this pickup truck, but rather I'm not a pickup guy, but I think there are 2 seats and there's a center console. Am I right about that factually? And so therefore, the area he's reaching into around his feet is in fact a little bit more cramped than it would be in a bench seat style pickup truck.
Potentially. I don't know that that's really reflected in the record. Okay. I would agree that there's a mention of a console, but I don't really think there's any fact to infer the size of the area around the driver's seat at all.
Thank you.
I'm also not a truck guy, so I'm not sure.
Go ahead. No, you go ahead.
Attorney Crane, I was going to ask on a different question, different topic.
I was just going to ask, did the judge make credibility findings one way or the other about Officer Trudeau's testimony that he saw an off-white powder in the corner cut baggie?
He did not. In the first ruling, he says the officers recognized a corner cut baggie. In the second ruling, he said there was nothing in conjunction in the motor vehicle with the corner cut baggie.
So how do we square that? Because in the first ruling, he said signs of impairment and reaching for a bag. And then the second ruling, it says did not observe anything in the motor vehicle in conjunction. How do those 2 different findings of fact get squared?
I think they can be read in harmony in the sense that this was a plastic baggie consistent with the distribution of narcotics, but that the judge did not necessarily credit that there was an off-white powder inside the bag, or there was nothing else additional in the car that suggested this was related to drugs beyond just the fact that it was the type of packaging consistent with the distribution of narcotics. That's why I think it's important that it needs to be viewed in light of the other two factual findings, the indicia of impairment and the reaching towards the bag, because that suggests the defendant may have recently taken some sort of substance, and the substance was still in the car, and he was actively trying to shield the evidence of that substance with his hand motions when he was reaching into the bag.
My question for you is, what's your view on the argument that the protective sweep portion of the motion was waived?
I think the issue is preserved. The trial prosecutor raised the issue of officer safety in his oral response at the motion.
The original motion.
The original motion to suppress. He talked specifically about the officer was fearful of his safety, and that was why he issued the exit order. There was also like a long line of questioning at the motion hearing around the exit order that the officer, again, testified he was fearful for his safety because of the defendant's motions towards the bag. And there was also a long discussion specifically on cross about the defendant needing at some point to go back into his car to retrieve his license and registration. I see my time is up. I'm happy to take any further questions, but if not, I will rest.
This is more of a rhetorical question. Why didn't ADA Healy ask Officer Trudeau what, if anything, is the significance of a corner cut baggie?
I wish he had. I think this would be a cleaner issue, but again, I do feel that there's enough on this record to conclude that this was a corner baggie, which was consistent with the distribution of narcotics. Thank you.
Okay, thank you very much. Good morning.
Good morning, Your Honors. My name is Sarah Varney. I'll be arguing on behalf of the defendant, Morris Clemens. Now, there's a popular adage in the medical world that when you hear hoofbeats, think horses, not zebras. That is, you observe facts, you make reasonable inferences from those facts, rather than assuming the unlikely. But in this case, the district court properly suppressed the evidence obtained in the warrantless search of Mr. Clemens' truck because the officers and now the Commonwealth have effectively been hunting for these zebras. They're relying upon unsupported and even dispelled hunches, which fall far short of the specific articulable facts that are actually necessary for a finding of probable cause. And this really happened kind of at those 3 points that the Commonwealth has already laid out. First, Officer Trudeau described a driver he had just woken up at night, being lethargic and disoriented.
I think you can assume we're familiar with the facts. Is a glassine bag and a corner cut baggie, are those equivalently benign, or is one more benign than the other?
Your Honor, I think one is kind of a subset of the other. But on this record, there isn't actually enough of a description for us to draw any conclusions about that object that was seen in the car, because the only description, or the most detailed description really given of it, is a small clear plastic bag. We don't know if it is a glassine baggie. We don't, as Justice Wood pointed out, know if it's a small Ziploc bag that's just a food
Is plastic
container.
the same as glassine?
Presumably, yes. I think the
How,
source would give them.
presumably based on what?
I think a thesaurus would probably give them as the same options in my or same as homophones, but I think a glassine bag, in my understanding, is how officers would regularly refer to a clear plastic bag.
Well, a lot of the cases from the 90s refer to glassine bags as used in drug distribution, including Garcia, but then that doesn't seem to have been used after a certain point. Was the kind of bag being used different at some point? Are glassine bags transparent?
In my understanding of what a glassine bag is referring to in these other cases, it is a clear plastic bag. I don't know if the language changed, but on the record here, it's described as a small plastic bag. And in Garcia, it being a glassine bag was insufficient.
But what's your understanding based on that a glassine bag is the same as a plastic bag?
My review of the cases, my understanding of just the meaning of the word glassine. And it seems consistent with a small clear plastic bag, but again, that itself does not make it consistent with narcotics distribution. And though the Commonwealth has sought to really distinguish Garcia, what's striking is actually the Commonwealth's claim in Garcia and here is the same, that there is probable cause to search based on a purported corner bag. And the decision in Garcia really does control here. But in Garcia, where this court said there was not probable cause, the Commonwealth actually presented more evidence on the record than is on the record here.
If glassine is not transparent, does Garcia control here?
If glassine is not transparent, I don't think that that necessarily has an impact on the analysis. Because what a transparent plastic bag is a benign object. As the officer himself conceded, clear plastic is a common type of trash that's seen on the floor of cars. So whether the officer could see into the bag, and I think we can infer from the facts of Garcia, given that after he had seized the bag, he shone a light through it to examine it more closely. This is again a stop at night, so he's picking it up and looking at it with a flashlight. He was able to see the contents. I think the glassine bag from that we can infer was clear, but that is really not.
If he needed a light, don't we infer the opposite? That it might be translucent, but it's not transparent.
Well, I think in that case it's because it was at night, so he picked it up to examine it closer with a flashlight. And ultimately that, though, isn't the deciding factor. There, the officer at least described that it was a transparent glassine baggie. That was actually the quote in the case. And it was about 1 by 1.5 inches.
Wait, sorry, can you just say that again? So in Garcia, they said transparent.
I do actually have that quote in front of me, yes, Your
Okay,
Honor.
so I think we can agree that transparent in that case and glassine were synonyms.
Yep.
Good, okay.
So in Garcia, the trooper at least described the size and general appearance of this bag and testified that he recognized that bag as the type of object used for the distribution of drugs in his training and experience, which included a narcotics training in the prior 10 days. Even there, that experience and that observation was not enough for the court to find probable cause in that case. And we have even less here. We have the clearest physical description as a small, clear plastic bag or a small bag. Ultimately, in the context of this case, that doesn't even give us any sense of the size because the canvas bag was also described as small.
What do we do with the fact that it's corner cut?
We don't actually know that for sure.
Didn't the judge find that in his first findings?
So I think the judge essentially quoted testimony, but in the testimony itself, there's no description of how this bag was made. The only description of it as a corner bag actually came from Sergeant Levesque. We don't know the precise basis. And even if the judge is relying on it, the characterization of it as a corner bag, and then referring to maybe what he's familiar with as a corner cut bag, that actual description is not on the record. There's no description where we might expect a corner cut bag to be triangular. There's no description of it being triangular.
So was the judge's finding at RA 43 that Sergeant Levesque clearly recognizing a corner cut baggie, is the fact that it's corner cut clearly erroneous?
I believe it is actually erroneous because it's not actually on the record. And it's not even the wording that Sergeant Levesque is reported to have used. And what's more important is we know from Garcia that an officer's characterization of an object as a corner cut bag is not what controls. It's the actual facts in the description and whether that is sufficient to describe or to determine that that bag is anything other than a scrap of plastic. And that is because there are a whole slew, as this officer admitted, there's a whole slew of kind of trash and different objects that can be found, as this court addressed 30 years ago in Garcia, that can be found just kind of in a car. This officer specifically admitted that clear plastic is a common type of trash to be found in a car. And yet, despite not relating any of his own training and experience, never once actually claiming on the record, I went looking for this, that this particular object was consistent with narcotics activity in his training and experience. The only testimony about training and experience actually related to the contents of the canvas bag, which he saw only after this initial search and as a result of this initial search. So because we don't have any of that, we actually have less information on the record here than we had in Garcia regarding the object itself. And the surrounding circumstances don't actually help it. The unfounded leap, I think, from this scrap of plastic, this small, clear plastic bag on the floor, to this is evidence of narcotics, I think flows from Officer Trudeau's earlier assumptions, where he saw Mr. Clemens being lethargic and disoriented when suddenly awoken, and assumed that was not evidence of him being tired or even what the officer conceded was kind of normal grogginess upon being awoken, and leapt to the conclusion that he was intoxicated.
Well, there were some interesting circumstances around it. First of all, the car is stopped but not parked. The driver is slumped over the wheel. There's a bag in the footwell of the driver's area, ostensibly where the driver's feet would be occupying if you were driving the car, that are a little different, or that may be suggestive that it is not simply a matter of being tired, pulling over to the side of the road and falling asleep. Is that
Your Honor,
true?
there's a few pieces to that. The first problem is that those initial observations really didn't support his assumption, and they were really missing a lot of what we would typically expect from police observations of someone who is actually intoxicated. But also, by the time of the search, and as the Commonwealth characterized this is an evolving situation, we have to take into account the totality of the circumstances that are known to the officers when they conducted the search. And they don't get to disregard things that dispel their suspicions.
But what about the judge's finding that at the first ruling on the motion to suppress, that the defendant was showing signs of impairment? I'm not saying that he was under the influence or that he was intoxicated, but that he was showing signs of impairment.
Well, Your Honor, that finding, I think, needs to be considered in conjunction with the fact that the judge ultimately reconsidered his ruling.
So you're saying by reconsidering his ruling, the judge basically vacated that finding?
The judge's final factual finding is that there was not sufficient evidence in this to determine that this bag was anything but a benign object. I don't believe Garcia was actually addressed in that original motion. It was then brought up in the motion to reconsider.
Newly discovered.
As this court had recently kind of affirmed it in Torres and made clear that that was still good law. In light of that case, in those circumstances, I think the point of the motion to reconsider in that ruling is that the judge went back and looked at all of the circumstances of the case and determined that there actually wasn't sufficient, or wasn't a sufficient factual basis for the officers to kind of leap.
Where in the record does it show that he went back and looked at all the circumstances? Did he have a transcript of the hearing from 4 months before?
So, Your Honor, I know that the judge does have access to recordings. I don't know exactly what he considered. I'm sure that he looked over the briefings.
But he didn't say on the record that he listened to the audio.
No, but he was the judge who actually conducted this hearing in the first place and made findings initially. So I'm sure that he went back and looked at his initial factual findings as well.
Do we need to remand for him to clarify whether or not he negated his initial findings that there were signs of impairment and defendant reaching for a bag on the floor, and how that squares with his subsequent finding that the police did not observe anything in the motor vehicle in conjunction with the corner baggie that justified a search? How do we square those?
Well, Your Honor, a remand here isn't necessary because we have the record, we have his ruling, and we have the case law. We have all of the pieces to put together. From his 3 points that he found, there's actually no indication of what weight he put on those, and we can actually look to the record to understand even the proper weight to be given to them. And ultimately...
So did he find signs that the defendant showed signs of impairment and that he was reaching for a bag on the floor, or not?
In those limited words and a margin notation, yes. He didn't go into precise detail of them or explain the weight that he gave. But again, the motion to reconsider, he ultimately determined that this should be suppressed, and that was the correct ruling, as this court can see on the record here.
So, for example, I'm looking at his tiny endorsement decision, the D showed signs of impairment. We all agree, I think, that he showed signs of impairment in the sense that he was sleeping in the car on the side of the road. I think the record demonstrates beyond any doubt that then, after field sobriety tests, he no longer showed signs of impairment. So I'm struggling, so that's the question, I guess. Is there any additional sign of impairment after he's successfully completed the field sobriety tests? I guess that goes to Justice Hand's question about location of the car. Maybe you address that. The car being in park and him having this bag a little bit oddly, I guess, at his feet as opposed to some other place.
The car was in drive.
Right, the car in drive. So are those signs of impairment?
So, Your Honor, I think the initial observations are just as likely to be signs of someone who realized that they were driving, becoming tired and pulled over, and didn't get the car in park, as they are to be signs of impairment. And the fact is that the field sobriety test came after. But even in that initial interaction, the only observations that kind of supported this signs or these indicia of impairment are the position of the car, the fact that it wasn't in drive, and his disorientation and kind of lethargic presentation right after being awoken. There is no indication that his pupils were pinpoint or sluggish, that he was slurring his words or unsteady on his feet, that he was agitated or aggressive or behaving abnormally beyond just kind of this lethargicness. And when he was awoken, that series of events is not in dispute on the record. When he was awoken, he kind of was startled awake by an officer at his window. His foot seemingly came off the brake, causing the car to move slowly forward, not like gunning forward or careening out of control. And he immediately responded to an order through the closed window to put his truck in park.
You're running short on time and we know the facts. Is the judge's finding that a corner cut baggie is a benign object a finding of fact or a conclusion of law?
I think on that point it is a conclusion of law because it is based on the facts and the decision in Garcia affirmed by Torres and his review of those facts. And on Garcia, again, comparing just the facts and the legal reasoning here, we have more on the record in Garcia than we actually had here. And the weight given to those various factors can be reviewed in this analysis. And as Garcia said, what is described on the record here is a benign object.
What about the fact that Officer Trudeau said he saw an off-white powder?
Your Honor, I think the context of that statement and the fact that it's not actually in the factual findings made ever by the judge matters here. That statement about residue came on cross when he was asked and actually kind of came at the end of a rambling generalized answer that wasn't really precisely a description of this object. And notably, it was not in his contemporaneous report. So really, the first time that this mention of some sort of residue, which he also described as potential residue, maybe something kind of hedging back and forth, is not enough for us to even conclude that that is drug residue. And he never even claimed that it actually was or gave any sort of training and experience as a basis for that. So for those reasons, we would ask that you affirm the suppression order.
Thank you both very much for your arguments. The matter is under advisement. Our next case is Commonwealth versus Robert L. Brown, 2024 P0512.
May it please the court, Andrew Levchuk arguing for Mr. Brown.
If you could speak a little bit more loudly, it would be helpful.
Yes, Andrew Levchuk arguing for Mr. Brown. Mr. Brown brought a facial challenge to the firearms regime.
So I hate to jump right in and cut you off, but I'm really struggling. So there are at least three versions of this statute, the licensing scheme, 131D, since he was charged. Am I right about that?
There are at least two that I'm aware of.
Okay, well, let's go through them. The first is the one that was actually in place at the time of his charge, right?
Yes.
Okay, and then the second one is passed on effective in August of 2022 after he's charged, right?
Right.
And then there's actually a third one that is irrelevant for today.
Right.
But you, in your appendix, included the second one, the one that was passed in August of 2022, right?
That's correct. And
Okay, and we all agree that that's not in play here, right?
That's not in play, although I will say that the amendment to the relevant challenge that we made was fairly minor. The suitability criteria, which is what we focused our challenge on, essentially are contained in the statute that was in place at the time of his, that he was arrested.
Okay, you're
And
saying that, you're saying essentially the language of the controlling version at the time he was charged is indistinguishable from the, on suitability.
Materially indistinguishable.
Materially indistinguishable. Okay, so jumping right to the substance of that, assuming we accept that you gave us the wrong licensing scheme, but it doesn't matter. It's effectively the same as the one that actually applies.
Right.
Assuming we accept that. Your complaint, in the simplest way I can boil it down, is to the suitability component of the statute, right? Of the
Yes.
licensing scheme. Yes, okay. And I think the SJC has told us, pending whatever post-argument briefing we allow, that suitability determinations are consistent with the Second Amendment. In plain English, figuring out if people are dangerous is consistent with the Second Amendment as a basis to exclude them, prevent them from having firearms. Isn't
That's
that
correct. In Marcus, that's what they held.
okay? So in the universe and in this regime that we're talking about,
Yes.
the licensing authority may choose to deny a license to people within that universe. Is that right?
That is correct.
Okay, so those are people that are not burdened by the Second Amendment to be subject to discretion from the licensing authority.
What the SJC said in Marcus was the current version of the statute enacted in August 2022. The suitability definition there is constitutional under the Second Amendment, and it doesn't vest undue discretion in the licensing authority.
Right, but I think we just agreed that the version that he was charged under that you didn't give us is materially indistinguishable on suitability to the one that the SJC passed on.
Understood. I'm not arguing with you.
Sorry?
I'm not arguing with you. I agree.
Okay, all right, thank you very much. I appreciate that.
Yeah, no, and you know, I will say we wouldn't waive the claim in case the Supreme Court should ultimately get involved. Our concern about the suitability definition was that, you know, a mere suggestion that an applicant may, you know, cause a public safety problem or be dangerous to themselves or others is too vague for meet the Second Amendment criteria under Bruin. Justice Gaziano's opinion rejected that in Marcus. And whichever version of the statute you apply, I think I would have a very difficult time arguing that we can somehow overcome the Marcus decision. But I would ask when the court makes a determination as to what further briefing it will allow, that we at least be allowed to address Marcus and the findings there, and its relevance not only to that claim, but also to the storage, to the extent we can find relevance to the attack on the storage requirement. And unlike Marcus, though, its companion decision in Donnell actually helps us.
On storage or generally?
I'm sorry?
On the storage issue are you talking about?
I would argue on the storage issue, but most directly, I believe, on the facial unconstitutionality of the statute as it existed at the time my client was arrested.
Where did you argue that statute at the time that your client was arrested?
Did not argue it, but
Right.
Donald came down 8 months after. And so our focus was entirely on the suitability question. So we have not had a chance to take advantage of Donald's finding. Donald, as the court is aware, was focused on the issue of out-of-state individuals and their applications for licensing. And to the extent that it was focused on that, it nevertheless sort of considered that at the time there was a may issue statute in effect, and the requirements for a license to be issued to an out-of-stater were subject to the may issue versus shall issue.
Right, but that may issue regime was regarding prohibited persons. people who were not prohibited persons.
Right.
Right. And so that universe, that piece of that regime is categorically different than the universe of people who are unsuitable, I think. In other words, the people who are found to not be prohibited are, in other words, are otherwise entitled to bear arms under the Second Amendment. There's a discretion there. The licensing authority may choose among that subset of people who have a Second Amendment right to deny the right to bear arms. That's the problem, I think, that Donald was addressing. But so first of all, you didn't raise that's a totally different argument than the argument on suitability that you actually raised in your briefs.
It's a different argument, but it is one that has been a finding of the Supreme Judicial Court while my case is pending. And I certainly think my client is entitled to assert whatever is helpful in that opinion.
Okay, but just so we're being clear, you have not yet made that argument in your briefing.
I have not yet made that argument.
Okay.
I think for among the case I cited in my reply to the opposition for a stay, I think we're entitled to make it. And that's where we are now. But I will also say that Donald found that the statute was facially unconstitutional, and in particular, what it said was that, look, you had a May issue statute which Mr. Donnell would have had to apply, under which he would have had to apply for a license. And that fact, along with the fact that Section 131F vested complete discretion in the colonel of the state police, those two facts led the court to find that the statute was facially unconstitutional. So in other words, if one finds that that analysis also applies in our case, I believe our defendant, my defendant, and any defendant who didn't apply for a license prior to August 2022, I think those convictions are suspect, all of them.
And you think we should rule that here, where your client never moved to dismiss?
Well, yes, because if it's a facially unconstitutional statute, he's been convicted for not applying or not complying with the facially unconstitutional statute.
I understand.
I think it would be inappropriate and a manifest injustice to sustain his conviction.
But procedurally, for example, in the Springfield District Court case that you cited,
Yeah.
that defendant filed, I think, a 25B2 motion.
Yes.
So the trial court decided in the first instance the issue. You're saying we should decide in the first instance whether the statute's facially unconstitutional?
Yes, because it's a purely legal issue, and even though no objection was made, that can be excused under a couple of grounds. There is the clairvoyance exception, which we argue in the brief, which essentially says if you have, a rapidly developing area of the law or something that wasn't familiar to everyone
At what point in the proceedings should the Commonwealth have introduced colonial statutes that may be historical analogs?
They should have introduced them as soon as Bruin was decided.
Just apropos of nothing, here's a memo about
Well,
Bruin?
no, it wasn't, but it wasn't raised by my client, and it wasn't raised below. And so, yeah, they didn't have the opportunity to argue that. But because we're here on a purely legal issue, they had the opportunity to do that here, and frankly, failed at that.
So are you saying that there are the opportunity to develop a factual record, which I guess would include historical analogs, is irrelevant to this facial challenge?
Depends on whether you consider a historical record factual. I consider that a legal argument to be made to this court. There's no
Commonwealth hasn't had notice of that until, I guess, today or when you filed this motion.
No, that's not true at all. In terms of, we're arguing now about the storage statute.
Oh, okay.
Yeah, I mean, I raised that back in the initial brief.
Do you happen to know if there are any colonial statutes about the storage of gunpowder?
Yes, they cite a storage of gunpowder statute. Gunpowder very dangerous. It can explode. It's a bad thing to keep in your house. It's not like keeping a firearm.
But so when Bruin talks about the statute doesn't need to be a perfect twin, but it needs to be analogous, doesn't somebody need to have a hearing with maybe testimony of historians about powder houses and why gunpowder was stored in powder houses and open flames, and the fact that because of the technology, the ammunition was more dangerous than the firearm?
Right, and I would welcome such a hearing if the court feels it would be helpful. I don't know that you all need that. We could do further briefing on it. We could ask, historian Amisi to come in, or the court has the option of sending it back to the district court and having the district court make findings.
Can I ask, standing? The Commonwealth says you lack standing. I understood your argument about waiver and the clairvoyance exception. That's the waiver doctrine. Do you understand their standing argument to be materially different than a waiver argument?
I don't. I don't know what they mean. It wasn't clear at all to me why they're using the word standing.
All right.
In other words, my client, is he seeking to redress an injury that he has suffered? He has, under the law of the Commonwealth and the law of the United States, and that seems to me to be sufficient to grant him standing. But I would also say, Justice Wood, I do want to get back to your point about, including the post-August 2022 version of the statute in my brief versus the pre-2022. I mean, if that, given the argument I made, which unfortunately Marcus has now pretty much rejected, it didn't matter, and more fundamentally, to the extent that it's going to be held against anyone, it should be held against me and not my client. Because the argument, I think, has merit, which the Supreme Court may or may not ever reach. We don't know that. But on the other hand, if 20 years ago somebody told me I'd be up here arguing that we should be finding statutes from 1789, I wouldn't have anticipated that
I understand
either.
your argument that you don't feel that you should be confined to the arguments in your principal brief because Donald is important.
Yes.
What happens if another case comes down, after you brief Donald? Should we keep extending the opportunity for you to brief any new Second Amendment cases that come down?
Well, I think that's a case-by-case determination, but Donald is so on point, and it's the first case to deal with the pre-2022 version of the statute that I think, and the court, I don't know what your collective experience is, I don't think that sort of thing usually happens where you get seriatim requests for additional briefing. Perhaps it has, but it's not happened in my experience. So in conclusion, I think we would like to be able to brief Donald. We'd like to be able to make those arguments. And we think that Donald raises the serious possibility that the statute in place at the time of my client's conviction is facially unconstitutional. If the court has no further questions.
Thank you very much.
Thank you.
Christopher Nichols for the District Attorney's Office of Hendon County. May it please the court. The Commonwealth would just want to start off by piggybacking off of one of the questions that Justice Wood asked, which was about the Commonwealth's standing argument and how it relates to the issue of waiver. The language that the Commonwealth used with regard to the issue of standing came from, I believe it was the Randolph case, but I don't know that there's a entirely substantive difference between the issue of waiver and standing. In essence, the Commonwealth's argument is because the argument was waived below, the defendant doesn't have standing to bring it forward today.
Right. So if it's waiver, which is what Randolph describes very well, by the way, I think it's clear that he does get to make an argument. I mean, that's at just the beginning. That doesn't mean anything more than that. But in other words, he's not barred from making the argument. All arguments, including waived arguments, must be considered. And the question is whether it creates a substantial risk of a miscarriage of justice, right?
I think the Commonwealth actually disagrees with that.
Okay.
If the argument isn't waived below, especially as it pertains to facial constitutional challenges, which are the ones that are at issue today, then they typically, absent some more specific circumstances that in the Commonwealth's view don't apply to the defendant in this case, don't get to bring those challenges.
Wait, sorry,
If you bring the microphone a little
yeah, sorry
closer to you,
about
I
that.
think.
that was
So-
actually, I think that's an important point you're making, but I didn't quite follow it. And let me reframe it. I think you're saying facial challenges are a subset of waived claims, and they have a different analysis. If that's true, then what's your best case for what I'm hearing? Either reframe my restatement of your argument correctly, correct me, or if I could get the best case, that would be great, that a waived facial challenge may not be brought. Is there case law that establishes that?
So I would suggest that the Harris case directs that question most directly when it says, and I think the quotation is, because the defendant did not raise this argument below, it is waived. Powell, there are cases in which the lack of having raised the issue below is addressed in an appellate posture, and I would suggest like Gordado, for example, is one in which the defendant didn't raise a challenge to the 10A statute, but was allowed to do so in an appellate posture because Bruin was decided after his trial. And that's kind of, and in Powell, a similar circumstance as I recall. But here, Bruin had been decided before the defendant's trial. Gordado had been decided before the defendant's trial. The trial counsel had the law, the newest version of the Second Amendment jurisprudence available to him at the time of the defendant's trial, and no argument challenging the facial constitutionality of either the SORB statute or the licensing scheme was raised. And in that posture, the defendant lacks standing to bring it at this point. And so that's kind of the distinguishing thing, is the timing. When were the seminal cases decided, and when was the defendant's trial? And so the Commonwealth's argument, again, to iterate, is that it's not properly before the court, essentially. I do understand that there are exceptions in which the court may consider it irrespective of that, but in the Commonwealth's view, because the case law, specifically Bruin, which is, I think, what a lot of these arguments hinge on, had been decided for the defendant's trial, in the Commonwealth's view, it's waived. So, setting that aside, I do want to address more specifically the arguments about the facial constitutionality of the statutes at issue. The one I think that I'll address first is the storage statute, the 131L. And as a kind of a reminder about how facial constitutional challenges work, and I understand the court knows, but it basically has to be constitutional in every instance. And I think this one's the most clear-cut, which is that if a person, for example, leaves a firearm in their unlocked car and then walks into their work at an elementary school, that's the kind of situation in which we would say, no, that firearm needs to be secured. There needs to be some kind of lockbox. There needs to be some kind of disabling mechanism.
And that's consistent with the historical analysis under the Second Amendment.
That's, yes, in the Commonwealth's view, and I think that that's been iterated through Heller, Bruin, Rahimi, and all the way through the two most recent decisions that the SJC has issued regarding firearms generally, which is public safety is a paramount concern, and that there are some regulations that are allowable and acceptable, and one of the ones that is basically throughout the course of the nation's tradition of firearms regulation is making sure that the firearms are kept away from people who shouldn't have them, and that they are kept in a way that is safe. And and I would say even I know this isn't an as-applied challenge, but even with what occurred with the defendant in this case, we have a person who left their firearm in a backpack in the unlocked car and then walked away, went behind a building.
But just, it's so complicated. To keep us clearly focused, you made the point, that's an as-applied challenge. This is a facial challenge.
Yes.
As you've said, just so I have it clear in my mind, make sure I'm following you, that on the facial challenge to the storage statute, the question, the correct question, the constitutionally appropriate question is whether there's a version of the statute that is acceptable, an application of the statute that's constitutional. And as you just said, the guy leaving his gun in an unlocked car outside the school would be, by all historical traditions, permissibly punished and therefore consistent with the Second Amendment. That's what you're saying, right?
That is what I'm
That's your best argument, right? Well, sorry. Strike that. That's an argument you're making.
That is an argument I'm making.
Thank
yes.
you. Okay.
And but I think the examples that I can give about leaving firearms in places in which people who may not need to have access to them, like a child or a felon, are very clear cut. And so I think that the argument that 131L is facially constitutional is, I think, very clear. And nothing about Bruin, and nothing either about the two new cases, Donald, or I was pronouncing it Marquis, but if it's Marcus, it's all right. We'll go with Marcus. Marcus doesn't change that. Now, turning from that argument now to the to 131D, the licensing statute. The court did ask if there were differences between the pre-22 amended version and the post-2022 amended version. The answer is yes. There is the obvious difference between the may and shall language.
But he's not challenging that portion, and that relates to prohibited persons, right?
Right. But I just want to make sure that it is clear that there is that distinction. In addition, I believe the post-2022 amended version added the word articulable to the definition of what a suitable person is. And so there are some distinctions there. But in my understanding of what the defense's main qualm with it is the word suggests. And my reading of the district court case that is often cited by opposing counsel, the Westbrook v. Pratt case, also focuses on the word suggest as giving too much discretion to the licensing authorities. And in the Commonwealth's view, that word does not render the licensing framework unconstitutional, because, as I mentioned in my brief, and I'll just iterate here, the courts have kind of honed in the meaning of what is allowed, what the licensing authorities are allowed to weigh when they make a determination of a person's suitability. And it's objective criteria, it's criteria based on reasonableness, and it's criteria that also relate, and this is paramount, to issues of public safety. And that's the standard that is in keeping with the nation's tradition of firearms legislation. Is this about firearms? Is this about public safety? And if the answer is yes, then okay, how are we regulating it? And giving licensing authorities some discretion to weigh objective factors in consideration of public safety risks is something that is consistent with Bruin and is something that's consistent with the nation's tradition of firearms regulation. And that's what Marquis indicated, and that's also what Donald indicated as well. Because Donald was addressed, I do want to bring some attention to it. It's obviously a different section of how the Commonwealth regulates firearms, but there are some similarities between the 131F and then 131D. But I think that the differences are kind of go towards the Commonwealth's favor.
The Commonwealth's favor.
Yes. So the discretion that the licensing authorities had under 131F, I guess there's three parts that the court highlights as being problematic. There's the may issue, plus the may deem proper, plus the use of discretion when renewing a firearms license. And those three things added together mean that the licensing authority had too much discretion under 131F prior to it being amended. But when you compare that to the amount of discretion that the licensing authority has under 131D and the suitability requirement, it's different, because in the pre-amended version of 131D, there was There was the may language as opposed to the shall, but there wasn't the may deem proper language.
It wasn't what? I didn't hear the second half of your sentence.
Yeah, the may deem proper language
Okay,
doesn't show up in 131D. That's a 131F language, but it doesn't show up in the suitability definition of suitability, and it doesn't appear elsewhere in 131D. And that distinction is important because it seems to be the combination of the fact that it's a may issue statute, plus the may deem proper, plus the discretion to renew or not renew that was given to the colonel.
Can you remind me, I'm sorry, the may deem proper, what section, I know we're talking about 131F in Donnell.
Yes.
May deem proper, is that in the section relating to prohibited persons or in the section relating to unsuitability of people who are risky?
That, one moment, Your Honor.
Or a third section? I'm sorry to put you on the spot.
So it's in the 131F, and then it's, if you scroll past the subsection X, or 10, such licensee shall be valid for a period of 1 year, but the colonel may renew such license if, in his discretion, such renewal is necessary. The colonel may also issue such a license subject to such terms and conditions as he deems proper.
Right. Thank you. Thank you.
That language in Donnell gave the licensing authority too much discretion.
Yep.
But that language doesn't appear in the 131D language with regard to the definition of suitability and for, I guess, for resident licensees and applicants for firearms. So that difference it actually makes the difference between how the court should look at the 131D pre-2022.
Yeah, and that statute, the one that doesn't include, the 131D applicable to Mr. Brown, that doesn't include may deem proper, is the version that was actually in force at the time he was charged, right? Right, okay. So your argument is actually that Donnell's review of 131F does not control this case, the version of 131D applicable at the time of his arrest because of these three things. The only two of them were in the statute that Mr. Brown was subject to. The third, may deem proper, was not. Have I got that right?
That's correct.
And that makes, okay.
And if I may just piggyback off of that as well, the other distinction is that the may deem proper language wasn't tethered to any other kind of standard.
Yeah.
So the suitability standard is attached to language about public safety concerns and making sure that that relates to the licensing authority's discretion. When they're deciding whether or not a person is suitable, they're looking at public safety concerns. The may deem proper language wasn't connected to any language about public safety concerns or the safety of the community or any of the other things that are part of the history of firearms regulations in this country. So because one has and again, this goes back to the Second Amendment analysis under Bruin. Why are we doing this? Is it to regulate public safety? Yes. Then is how we're doing it also constitutional? But the problem with the 131F in Donnell is that because of the sheer amount of discretion that the licensing authority was given, might not even reach that first issue, which is we're not even sure why we're regulating the firearms. Or at least we're regulating the firearms in a way that might not be attached to issues of public safety. So in those two fronts, it fails the Bruin analysis, whereas you get a different result under 131D. And I'm mentioning Donnell, and I know in my response to the defendant's request for further briefing indicated that the statute that was presented before the court was presented in a certain way, but it seems that the question of how Donnell impacts this case is important to the court, and it was asked. That's why I'm bringing it up now. And we can see that I didn't address Donnell or the old statute of 2021D in my brief, but I think I mentioned why in my response. So with having said all that, if there's no further questions, I thank the court for its time.
Thank you both very much.
Thank you very
Appreciate
much.
your argument. And we will respond with additional information and a further order on briefing in a reasonable period of time. All right, our next case is Commonwealth versus Todd J. Maderas. That's 2024 P0431.
Good morning.
Good morning. If you just, okay, all set.
May it please the court, Devin Hincapié for Todd Medeiros. There's one fundamental question that is before the court today, and that is whether, as a matter of law, blinding sunlight can ever be an intervening and superseding cause in a motor vehicle homicide case, or whether a motorist who hits another person that he literally never saw because he was blinded by sunlight is strictly liable for the death, negligent as a matter of law. That's never been squarely decided in this Commonwealth.
Does the superseding intervening cause usually not act on the victim rather than on the defendant in a situation like this?
In the cases that the Commonwealth brings up, those are cases where third parties are attributed to be the superseding and intervening cause. I don't think it's necessary, and I plan to provide the court with a couple of cases where I think it demonstrates that that is not a requirement for.
What do you have in mind?
What do I have in mind? Well, I'd start with a case. Essentially, the Commonwealth's argument is that a blinding sunlight can never be an intervening and superseding cause as a matter of law. And the case that I think most clearly, I didn't cite any cases in the Commonwealth because there isn't any directly on point. But going back to a case out of the SJC that I think the reasoning is as clear today as it was then, Woolner versus Perry. And that case cite is 265 Mass 74. It's a 1928 case. It's an accident where the driver hit the rear end of a truck that had pulled off the side of the road because he was having trouble with his headlights, but he'd left the tail end of his truck about 8 feet in the lane of travel. There was conflicting evidence about whether the tail light of the truck was working. The one street light in the nearby could be found to have no aid to the driver in discerning objects in the road. And there was evidence that smoke from forest fires in the vicinity was blowing across the road that night. So by the time the driver sees the truck, he isn't able to stop in time and he crashes into him. And the truck driver appealed the trial court's refusal to grant his motion for a directed verdict. And the SJC discusses the general rule that drivers who collide with stationary or even moving vehicles in front of them are ordinarily guilty of negligence. But the court said, and I'm quoting, that's not an absolute rule of law. Each case must be decided on its own facts, and we cannot say that the only rational inference to be drawn from the facts present in that case is that the driver was negligent. And I think this case shows that there are circumstances where exceptions, like what's been called the indiscernible object exception in other jurisdictions, can wipe out a driver's liability entirely in a context where he would typically be at fault. And I think it also shows there's rules like you're at fault if you hit a stationary object in front of you, or you have to yield to oncoming traffic, may have no application when you're talking about a blinded driver. And imagine, put a person in the back of that truck that's killed because of that accident. The result wouldn't change. There's no act of a third person or other direct force that actively operates in producing the harm. Instead, it involves a combination of atmospheric conditions. It was nighttime, it was dark, there's smoke in the area, the street lamp was ineffective. The driver wasn't able to stop in time because those conditions made him unable to see. And normally, under the general rules of the road, the driver would be negligent, but the court, the SJC said, that's a decision for the jury, whether the driver was negligent. And so that very clearly is a case where it's got nothing to do with third-party forces or intervening acts of other people. And to go back to the...
Did the court discuss, I apologize because I'm not familiar with the case as you are, did the court discuss the superseding intervening cause, or did they discuss that situation as far as in another way?
I'm sorry, I don't understand your question.
When the court was talking about the interplay of those conditions, was it as a superseding intervening cause that they were discussing it, or were they discussing it in the context of foreseeability, for example?
Well, no, they're not, I don't think there were jury instructions at the time, quite honestly, and it's a civil case. I mean, a lot of these cases are civil cases, right? And so, so no, it's not talking about it, but what I think the reasoning underlying it is that there's an ordinary rule. You have to leave enough room that you can stop before you have to stop in no matter what time. You have to leave enough room so, you're going to be at fault if you hit the person in front of you. And in this case, the truck driver was trying to rely on that rule by suggesting there's no way that the driver is not at fault, that he's not negligent. And the SJC said, no, that's a question for the jury. And that's my point. I think that's the main, there's a couple of principles upon which I'm suggesting to the court, this court, that the only people in this case that could say whether blinding sunlight was a superseding and intervening cause of the accident that wiped out Mr. Maderos' liability was the jury.
Doesn't superseding or intervening mean that cause happens chronologically after the defendant's conduct? I would think your argument would be stronger if, for example, there was a bolt of lightning that happened after the defendant turned the corner and before he hit.
You're right that it has to happen subsequent. The conduct that we're talking about is Mr. Maderos creeping out into the intersection. That comes first. The evidence is that he creeped out into the intersection, waited for the truck to pass that he saw, and began to turn left at about 1 to 2 miles per hour. And the intervening event that we're talking, that was the theory of his defense, does happen after that. It's at that point after he begins to make the turn that the sunlight comes through the visors that are, it looks like he's got small visors in this small Ford pickup truck that blinds him after he begins to make the turn.
So my problem with this, I have two problems, but right now just this one, that the defendant understands the sun is there. The defendant understands, this is all before he's made the turn, that the sun is quite blinding. The defendant has testified, I adjusted my visor 4 times to block out the sun. And indeed, he successfully, effectively blocks out the sun with his visor before he makes the turn so that he can see the truck coming at him. What I don't understand from your argument, what seems like a critical flaw, is that he knows what's going to happen, or he should know, and maybe it's a question of negligence. When he initiates that turn, he knows that the sun is going to blind him, or at least get in his eyes. But before that, he should be able to see up the road the motorcycle coming, just as he saw the truck coming. Why have I got that wrong?
A couple things. So, absolutely, sunlight is a factor that he's aware of, that he's trying to make adjustments for by using the visors that are available in his car, by moving slowly. There's a couple differing, there's testimony from Mr. Maderos himself, the truck driver that's sitting right behind him. He's up higher, based on the kind of truck he was driving. And there's testimony from the 2 gentlemen that pulled up behind that truck. And that had like a 32-foot trailer. And the guy sitting up right behind him says that he saw the motorcycle coming down the hill, but then it disappeared. The guys behind him, the passenger says, I never saw the motorcycle. The driver says, I saw a headlight or a flashing light kind of up and then it disappeared, and I never saw it again until the motorcycle is going through the air. So, and I would disagree that Mr. Maderos knows what's going to happen. That's literally the definition of this intervening event that he didn't foresee happening. If he had, he may have done something different. Up until then, with the adjustment of the visors, he is capable of proceeding on his way. It's only when he turns that the sunlight comes through and blinds him. And I think that it is like a heart attack or a syncope where, sudden loss of consciousness. I don't know, I can't say we all, but there are those times where it's like a flash of a camera, you're blinded. That's
Yeah,
what
but
happens.
what I'm struggling with is Justice Grant's point about lightning, or your suggestion of a heart attack. The point is those are unpredictable. Nobody, and unpredicted. In the moment, nobody knows about where the lightning's going to strike. The heart attack, obviously nobody knows. Here, he knew already the sun was blinding. He knew, I submit, or should have known, what would happen when he initiated the turn. So I think it's fundamentally different because he knows the natural cause, the sun. He knows it's there. He knows it's blinding. And then he chooses to turn.
Okay, but what I would say is the point, the biggest problem here is that the point is that the jury is the one that is supposed to make that decision, they're in the best position.
And so on that point, that's my second problem. The jury was given, you laid out effectively in your briefing that the defense lawyer very effectively made the argument in openings, in examination, and in closings to the jury. The jury very well, it seems to me, had the issue in front of them. The jury was aware. My argument is the sun blinded me, and so therefore I wasn't negligent, not my fault. And the jury rejected that argument. I think you're only left with, yeah, but they didn't have the good jury instruction.
No, in fact, they have no law upon which to find him not liable because the jury instruction on motor vehicle homicide only talks about he puts, the defendant, you have to find that he puts in motion a direct, sort of a continuous sequence of events. And there is no discussion and there's no recitation of law that is correct, which provides the language of the jury instruction itself provides the defendant of the one he was requesting, the defendant must be acquitted if the death would not have occurred without the intervention of some other person or event. That's what he was arguing. This event, this independent event of the blinding sunlight. He wasn't blinded before he started to make the turn. He was blinded after he started to make the turn. That's the time that he was blinded. And that's his argument is that, and that's why it's a question for the jury, whether is that legit? Would a reasonable person have seen that when he made that turn that the sunlight is now not being blocked by visors? It's a very small visor, apparently.
Didn't they get that instruction, though, as part of the instruction on negligence? Would a reasonable person under these circumstances have acted in the same way? That instruction they got.
Sure, your foreseeability is what takes an intervening cause and makes it a superseding cause. What is the critical piece of the intervening and superseding cause instruction that's missing, that's not covered in the judge's instruction she did give, was a theory of defense that absolves him, legally speaking, of liability. And I also think that that principle that the jury is in the best position to determine whether an act or an event is an intervening and superseding cause of a person's injuries is also demonstrated by one of the cases cited by the Commonwealth, Delaney versus Reynolds, where that's the case where the woman shot herself with this gun that she thought, or maybe by past practice had assumed was going to be empty. And, if there's ever an intervening and superseding event, you'd think it would be suicide. But this court said, and in fact, suicide has been treated as a traditional and often categorical event. But this court said, no, the question of whether the risk of injury was foreseeable is almost always one of fact. And then finally, I see my time is nearing the end here. I'd like to address the Commonwealth's, they had to go to Iowa essentially to find a case that is on point, where the defendant is denied a requested instruction based on his theory of defense that the blinding sunlight caused the accident that caused the death. And the appeals court said, no, he's not entitled to it, but that was relying on a Supreme Court of Iowa decision that had found expressly that conditions such as light aren't going to be considered active forces that produce harm. That's in direct contrast to, I'm going to please give the court a citation out of Washington State versus Morgan, 123 Wash App 810, 2004, where the court found entirely permissible the defendant's argument that the blinding sunlight was a superseding intervening cause of the accident that caused the death. In other words, they said, if the jury found sufficient evidence to prove that blinding sunlight caused the accident, it could not have convicted Morgan because the state wouldn't have proved proximate cause element of the crime. And finally, in my review of other cases, are there others out there that show that blinding lights or blinding sunlight can be considered? I mean, that's really what this court is considering. Can it be an intervening and superseding cause? And if it can be, then the argument is that that was for the jury to decide in this case. And I found cases in California, Montana, Minnesota, and Nebraska. And I think it really just, it's a policy decision, and I'm asking this court to put that decision where it belongs. All he was asking for was a jury instruction. It was his theory of defense.
Thank you. I think we have your argument. Thank you very much. All set. Thanks.
Good morning, Your Honors. May it please the Court, Christopher Amaral for the Commonwealth. I'd like to first start by addressing something that Justice Hand had mentioned about the actual, what is a superseding cause and how it acts. And I'd like to kind of split the negligence issue of, which is the duty and breach for, and the causation. Superseding cause, I have here, excuse me, sorry. I have a bunch of citations here giving us exactly what a superseding cause is. So in this court gave us the words actively operating upon the victim or actively operating to create the harm, and that has to be unforeseeable. Black's Law Dictionary gives us this definition: a new and independent force which breaks the causal connection between the original wrong and injury and itself becomes the direct and immediate cause of the injury. The supplemental jury instruction that's at the heart of this case, the language of it presupposes that there has to be some other thing operating upon the victim when it says there are multiple causes of death. And in Commonwealth versus Putnam, which I have not put into my brief, but I can obviously give a 16-L letter to the court, the court says that explicitly. It says this is sorry.
It's okay, but so I think what you're saying, you're supporting Justice Hand's initial question at the beginning of the argument that the understanding is a superseding cause has to act upon the victim. In other words,
Correct.
The lightning or whatever has to hurt the thing, the natural event has to impact the victim, cause the harm to the victim. That's your point, right?
Correct, yeah.
And here, the blinding light is acting on the defendant can't see, the defendant then hits the victim. So you're saying that's not applicable, this is not a hypothetical in which that's applicable. That's your point?
Exactly, Your Honor, yes.
Great.
I have, although there's no on-point case in the Commonwealth, I have found an Iowa case, State versus Miller, that says explicitly, contributing factors such as road and lighting conditions against which the primary actor's conduct is being weighed to determine its culpability are neither the acts of third persons nor active forces that produce a superseding cause. So this has been looked at and addressed by other jurisdictions, and they've concluded that this is not, a superseding cause. My kind of understanding when I'm thinking about an intervening or a superseding cause is something that without the actor's negligence or without the defendant's negligence, the thing would have happened, the harm would have been created anyway. If a victim is riding down, and has a massive heart attack, without the defendant's negligence, right, or have not even being there, the harm would have happened anyway, right? We can say that's probably a superseding cause, right? The harm happens, nonetheless. On the point about foreseeability, which I think Justice Wood, you mentioned about the idea that the defendant is, he knows that, the sun is there, right? He drives down to the Dunkin' Donuts, The sun is there, maybe not quite so blinding. He comes back, it's very blinding or very bright. But nonetheless, he gets to the intersection and he can see a truck coming. So there's a point where he can see up the road. Somebody else behind him sees the motorcycle. So there's, we can say that, he waits, he turns, and once he's already, the event has already kind of in play. He's already into the intersection. He's already, the continuation of events is in. The sunlight comes into his eyes, and he says 1 to 2 seconds later, crash, and, unfortunately, the victim is struck. All of these things, and he does that, having sunglasses in the truck. He says directly on the stand that, oh, yes, I was stopped. It was safe for me to take them. It was, had I had them on, maybe or perhaps it would have made me a safer driver. And this court and the SJC has said, when you don't take mitigating actions, if there's something, there's a harm that you can predict, it's foreseeable, you don't take mitigating actions, it can't be a superseding cause or intervening cause. That was said in Mullins versus Pine something college, I forget. But in that case, a student is sexually assaulted in her dorm room, and the college is saying, well, no, the superseding cause must be the rapist. And the Supreme Court, SJC says, no, because there were measures that you could have taken. You could have had a higher security fence. You could have had the bolt lock or the knife lock, I think they call it, or all these different mitigating factors that you could have tried to prevent. And you knew that this sort of thing could happen. Like, it's not outside the realm of possibility that somebody could enter into a student's dorm room.
So even when, I guess your point, even when the what we might think of as the superseding cause acts directly on the victim, there are still cases like Pine Manor where the SJC says, yeah, except if it was foreseeable to the defendant, and the defendant could have prevented the intervening actor or made it less likely, then we won't hold the defendant. That's not a defense for the defendant.
Correct.
Right.
And I've cited multiple examples of that in my brief.
What about the point that your opponent makes that the instruction was not good enough? Justice Hand responds to that you have the negligence instruction, which of course includes duty of care. I assume, well, what's your argument?
So first, I would say that, one, the judge tells the defense counsel at sidebar, says, I'm not precluding you from arguing negligence. And during the jury instructions, gives a laundry list of things that the jury can consider. The weather conditions, the mechanical mechanism, if there's something wrong with the cars, the speeding, right? There's a whole laundry list that the judge gives. And this goes to the negligence, this is why I was saying that the splitting apart. This goes to the negligence bit. Was he driving reasonably, as a reasonable person would, right? Which is the standard and ordinary negligence in this case. The judge, I think, correctly looked and said, look, you can argue all of these things, right? And actually, before I even continue, the defense counsel in his closing argument actually tells the jury, the issue of causation is not an issue in this case. He says, we're only arguing negligence. We're not arguing breach. We're not arguing, damage. We're arguing only about negligence. There's no issue about causation. And so my interpretation of that is, if your whole case, as defense counsel kind of asserts, is based off of the idea that this is a superseding cause, the only defense, the only law that this defendant could have relied on was this jury instruction of, superseding and intervening cause, right? Without that, he's without any defense, without any shield. That's not correct. And even the defense attorney said, at trial says, this isn't even about causation, right? Really. So to the issue of...
I think your opponent would say, no, that's not quite fair. in determining whether someone was negligent, whether they breached their duty of care, you can consider other factors. Is what they want a more specific instruction, it seems like. The problem, I think, is the instruction itself, which actually was given, is what you may consider, among other things, what time of day it was, the weather, and the conditions on the road, and any other factors that you think are relevant, which, I mean, transcript 3, 186, 187. So I'm struggling to see the difference between the defendant's instruction and that instruction.
So, sorry,
Sorry, there's really no question there. I apologize.
Okay.
But that's the relevant transcript instruction, I think.
right. So to that point, and to your original question about whether this is something that goes to the jury or not.
Yeah.
I think you had mentioned earlier the example of, say, like a heart attack.
Yeah.
So let's say, the victim has a heart attack and, on his motorcycle, we have medical evidence that says that probably was the cause of death. He dies first and then gets struck, right? I think in that case we have, the judge can say, okay, well, we have two causes here, right? We've got, the defendant is on trial for striking and maybe killing this person, but then there's also this other potential cause of he has a heart attack, right? And there's evidence on both sides, right? We'll put that in front. I think that is something that we can put in front of the jury and say, okay, well, we'll have a medical expert and we have crash reconstruction evidence, and which facts can we weigh? I don't think the underlying issue of what is a superseding cause is something that goes to the jury. So it would be, maybe this is a bit extreme, but like something like we wouldn't have the jury decide whether or not somebody, jaywalking should be charged with manslaughter. That's not an instruction that we should be giving them, because that's on, sorry, it's a bit extreme, but.
But I was pondering your hypo. I think you were saying the guy on the motorcycle has a heart attack, and then the defendant does something reckless, and so there's a question whether they were both, well, there's an intervening event and the defendant's negligence caused it. What if the defendant had a heart attack and then causes him to go into the intersection?
So I think that definitely makes things more complicated. I think, not to fight your hypothetical, but to shift it a little bit, I think, say, if the defendant has, say, like a seizure, and let's even say that he's never had a seizure before, right? I think in that sense, I think in kind of like an odd abstract term, we can kind of almost put the blame onto the seizure, right? Because like the person isn't acting. There's no, in that case, there's really no negligent act for something to come after.
That's a superseding event that acts on the defendant, not on the victim. So that's why I'm pondering that.
Right. I would say, I'm tapping into my undergraduate philosophy here with my Descartes, but it's the way that I would kind of picture it is almost like the seizure itself acting upon, like the person who's having the seizure. If I have, if somebody's standing here and I have a seizure and I, go like this, I'm not the one who is doing it. It's almost like the seizure is the thing doing it.
There's no negligence first.
And there's no negligence
followed by the
first,
intervening
correct.
act, in your view. Is that the argument you're making?
Exactly. So, I think, unless there are any other questions from the panel, I'll rest on my brief.
Thank you very much. Thank you both. We'll take the matter under advisement. We are going to take a 15-minute break. We'll be out around 20 after 11 to continue with the remaining cases on today's list.
All right, please. Court is now in recess.
Rise, please. Court is now in session. Please be seated.
Thanks and apologies. Okay, good morning again. We are calling our fourth case today. This is the matter of John Doe, number 526978, versus the Sex Offender Registry Board. This is docket number 2024 P0069. I'll remind counsel that this matter is impounded. Please do not use proper names.
Yes, Your Honor. Good morning, honorable justices, and may it please the court. I'm Alex Hahn here on behalf of John Doe. Would acknowledge that this was a serious underlying offense involving a rape of an 11-year-old, and that the examiner's decision is fairly methodical in this case. I would also just to point it out that there's been a lot of progress for John Doe since the date of this offense, which goes back to 2016. The record establishes that he's well employed. He's employed by also his landlord, who's someone who's known for 30 years. So we can hope, and the indications are that it's true, that he will be marching on towards a future of lowered risk of offense. So that is certainly the hope, and there's all indication that that would be the case if he moved for reclassification. I think that evidence is worth thinking about when the court looks at the issue of where I would hang my hat, which is the question of, was this an extrafamilial victim? And the SORB factors are grounded in science. We don't always agree specifically with the language of the factors, but in this case, there is a lot of robust research around this factor, and the factor is so trenchantly written that for extrafamiliar victims, the risk is substantially higher of a risk of reoffense. So this is really a very important issue for the examiner. And, I do, of course, acknowledge that evidentiary issues are the province of the examiner. This is an interesting case where the examiner says that the evidence of whether the relationship between Doe and the victim was intrafamilial or extrafamiliar was contradictory or vague. And vague. And I note that Judge Ham below did say herself that the examiner could have found, in her view, that this was an interfamilial relationship. She then deferred to the examiner, which is, understandable, but again, we have essentially a candid admission or candid statement from the examiner that this evidence is, the term I would use, equipoise. It's not a term I've come across perhaps since law school, I would think, but I did see it in one of the cases I found. And it seems pretty clear to me that when you have something that's a jump ball, has SORB met its burden? Now, just to be clear, SORB's burden overall is one of clear and convincing. The burden on the subsidiary findings, including the factors, is clear and convincing. So it's relatively low threshold they have to meet.
Sorry, I think you said the subsidiary fact is clear and convincing. I think you're supposed to say preponderance of the evidence.
Thank you for correcting me, Your Honor. That's exactly what I meant to say. That clear and convincing is the overall burden of persuasion, and the individual factors, subsidiary findings, is the preponderance of the evidence standard. Thank you, Your Honor. Even so, that if this evidence is contradictory and or vague, that there is just simply not a possibility of SORB meeting its burden. So I think that's our argument in this case, Your Honor. And in terms of what that evidence was, it's really the victim that provides the strongest evidence that he was a stepfather figure, that he was there, a lot of the time, if not all of the time. And I think this victim, of all the people we see, the characters on the page of these DCF reports, the victim is probably by far the best reporter we see, in a very troubled set of family situations. So I think we could reasonably credit what this victim is saying in terms of him being a stepfather, a intrafamilial figure. Which
actually, can I ask you about that?
Yes,
Let's assume different facts. Let's assume there's no dispute that he had only met the mother a year earlier, but the daughter, the victim, identifies him as stepfather. Under this definition, you lose, right?
We would lose under the definition, Your Honor. I don't think the court would be, or the tribunal for that matter, would be precluded from looking at it more sort of holistically rather than rigidly. But I do absolutely concede, just from the plain language, that it has to be 2 years, before the offense.
Right.
Before the offending behavior.
Before the offending behavior, yes, Your Honor.
Right, so whether we like it or not, whether the research supports it or not, we have to find that there was not a preponderance of the evidence that the familial relationship was at least 2 years old. Did I get that right? Did I get too many knots? In other words, we have to find that there was an error on the question of the length of the intrafamilial relationship. It's not just that there was an intrafamilial relationship established. It has to have been at least 2 years, right?
Yes, Your Honor, that is my argument, and I acknowledge the language of Factor 7. Again, I think there is evidence from the victim that it was a mother who said that they'd been in this relationship for 2 years. From the victim, there's not any indication of the specific length. I imagine for an 11-year-old, temporal issues are challenging, but the mother is saying 2 years, and the victim is saying stepfather.
Right, but your opponent makes the reasonable point that, okay, so even except the 2 years on its face, that doesn't mean that he moved in initially. That I think means reasonably they started dating 2 years earlier. And so if we're trying to figure out how long there's been an intrafamilial relationship, I guess that means how long has he been a father figure or stepfather figure? That doesn't necessarily mean it's 2 years meaning from the date that they started dating, right?
That's absolutely fair enough, Your Honor, and in concept. And I guess the question is, what does this record show us? And, again, I fully acknowledge the standard of review, which is deferential to an examiner. I also note that in this arena there are constitutional rights at issue, so the evidence does have to be firm and clear. So the question is really, with this victim having reported stepfather and these other indicia of an intrafamilial relationship that did perhaps go that much further. And ultimately, with the examiner, those are the words that leapt out at me, is sort of acknowledging that this is a jump ball. And then my question, for the court's consideration is whether or not SORB can meet its burden. And the factor we're talking about, Factor 7, is far from trivial. So,
I have a question for you about Factor 7. What do we do with the letter of support that says that the defendant has been living next to me for the past 15 years at a different address from the one where the victim lives? And what does Factor 7 mean when it says, let me see, I need to get it again, lived in the same household with the offender? Does that mean 7 days a week?
I don't think there is actually, a clear definition of that, and that's maybe part of the issue here, and part of the reason. I mean, obviously there does have to be a certain amount of things that's to the interpretation of the examiner. I'm sorry, Your Honor, what was the first question?
It was about the letter of support.
Oh, yes, Your Honor.
That says, I've lived near the defendant for the past 15 years, and it's at a different address. I lived in the same building, I think it was.
Sure. I mean, it's not helpful evidence, and I pointed out, I did not try to run from or shrink from that evidence, and it's not helpful. I would say it sounds like something where he may have maintained a residence elsewhere for whatever reason, but was spending most of his time. And again, if we're going to look at this, if this factor were to be applied, somewhat holistically as far as the what constitutes a family member substitute, we'd probably look at a variety of things that might be more important than whether or not someone is, doing a bit of movement back and forth through different parts of the city. What is the role that he is playing for this child and for this family? And again, it sounds like it was a very horrendous situation.
You've made, I applaud your candidness, absolutely, but you've said holistically a few times, and I'm struggling. I like the idea of applying all of these factors holistically. That seems good, but at the same time, we have this factor 7 that says 2 years, and it's supposed to be 2 years living in this intrafamilial relationship. I'm struggling to reconcile that bureaucratic definition with your hope of considering intrafamilial relationship holistically.
Yeah, fair enough, Your Honor. I think, the examiners freely state at the beginning of most of their opinions that the evidence is supposed to be looked at qualitatively, and I think they often do, an excellent job of that. I do acknowledge to your question that I'm somewhat seemingly trying to import the notion of a holistic overview of all the factors to then become a holistic review of factor 7. And fair enough, Your Honor. Your language of bureaucratic, I would just jump off from that. I don't think any decision can or should be bureaucratic necessarily, that we have language that is sterile and bureaucratic, and of course if it's clear it has to be followed, but I would hope there would be a little wiggle room for any examiner, and I think often there is, that no matter how rigidly written the factor, we are talking about very complicated issues relating to evaluating risk of reoffense and constitutional rights for.
Absolutely, fair enough. I hear that completely. But let me shift to a different question. Let's assume that we put that intrafamilial question to the side, jump ball, equipose. Harmless error. So I think you said at the beginning, completely appropriately, this was a very bad crime. So you've got the 40-something-year-old offender, the 11-year-old victim, so that's bad. And then you've got the second very bad factor of the cousin in the bed next to this person. So in other words, level 2, for those, based on those two factors alone, regardless of whether he's an intrafamilial, is that unreasonable?
I think it's a close question. I'm going to be hard pressed to immediately concede that, although I think obviously it's a very fair question. In terms of what's bad about this case, there are some things, obviously, we agree on that. Nonetheless, this is his only sex offense. So in responding to your question, Justice Wood, basically to say that there are many other factors that apply in some cases which don't here, in this case, that are bad, that are bad to worse, such as repetitive and compulsive offending. This was his only offense. It is a troubling offense against a young girl that involved force. It is his only offense, so we don't have any sort of factor 2 repetitive and compulsive, which is really the most glaring risk elevating factor out there. There certainly is force involved, which is a factor. In terms of the factor 6, I believe it is public place. My view, and this is not something I delved into in this case, for better or for worse, but the science around factor 6 is not as robust. The notion that this sort of because it occurred where another human being is, that indicates a strong lack of impulse control or something. Certainly it evidences lack of impulse control to commit this offense, but the fact that there was another individual there asleep does that really elevate his risk? I don't think that's borne out scientifically. I realize this is essentially just speculation at this point, or musings about these issues that might come up in another case. But I think the public place factor is really written for, the person that's hiding behind the tree. That's where we get the main risk elevation there. So I don't think it's an overwhelming case where we could say, if we knock the leg out from under the stool of this factor 7, extra familiar being so significant as a factor, and I'm about out of time. But if we were to say there was not a burden met on that case, is this one where we could say, completely harmless error? I'm not sure, Your Honor. And if there's no further questions, thank you very much, Your Honors.
Thank you very much.
Good morning. May it please the court, Gabrielle Lamano on behalf of the board. What this case really boils down to is whether the hearing examiner's determination that the victim was extrafamilial, was that reasonable based on the evidence? And I would suggest that it certainly was reasonable based upon the evidence here. As Your Honors pointed out, Factor 7 kind of comes down to 2 points in this case in terms of intrafamilial versus extrafamilial. There's first the issue of, was he living in the home as a full-time family member substitute, as the regulations describe, and then there's the issue of the 2 years. So first, to address the family member substitute, the evidence was not strong that he was living in the home full-time as a family member substitute. We do have the victim reporting that she called him her stepfather, although the hearing examiner points out in her decision that the DCF records say she referred to him as her stepfather, but there's sort of multi-levels of hearsay because she makes this report to a teacher, the teacher then reports it to DCF, and this is what's being relayed in the DCF records. So the hearing examiner points out that it's unclear whether the victim herself used that term stepfather or whether it was the teacher's interpretation of the victim, the relationship that the victim described. But in any event, the victim says that and says that he spends the night at the house every night. But the victim is an 11-year-old girl, and as Attorney Hahn pointed out, her memory and her ability to judge time may not be the best as some of the other adults who do report that he does not live there. Her brother, who's 17 years old, reported to DCF that he spends the night, but that he does not live full-time with the family. The mother also reported the same thing, that he has a residence in Dorchester, that he stays at her home 2 to 3 nights per week, but he does not live with the family. That's also consistent with the other evidence that I think Justice Wood pointed out is the letter from, there's not only a letter from the neighbor, there's a letter from 2 neighbors that talks about, I'm sorry, Justice Hand, there's a letter from 2 neighbors that talks about him living at an address in Dorchester. The petitioner himself also submits an affidavit. Now that affidavit is submitted in 2021, just prior to the hearing. So whether he was living in Dorchester in 2016 at the time of the offense, the affidavit isn't obviously dispositive on that, but he does submit an affidavit giving an address in Dorchester. And that's the same address that the neighbor says, I've lived next to him for 15 years at this address. So we have the petitioner's evidence suggesting that he maintains this residence in Dorchester. He has done so for a number of years. And then we also have the victim's mother and the victim's brother reporting that he comes over, he spends the night, but he doesn't live here full time. So I think given that, judging under the preponderance of the evidence standard, it's certainly reasonable for the hearing examiner to conclude that he does not live in the home full-time as a family member substitute as described in the regulations.
I have a hypothetical question for you about how SORB applies Factor 7. Assume hypothetically that there's a child whose parents are divorced and the parents live separately, and the parents have 50-50 custody, so the child spends exactly 50% of the time with one parent and 50% with the other. The mother remarries, and the stepfather rapes the daughter in the house. The stepfather lives in the house with the mother. Would SORB apply Factor 7 after 2 years, even though the daughter only is there half the time? Or would SORB wait for 4 years or something? Or is there some holistic way of interpreting the statute?
Right. I think it's difficult because there isn't a clear definition in the regulations about do they have to spend 4 nights a week or 5 nights or full-time or anything like that. But I think, so I think certainly either determination could be reasonable under the regulations because there isn't this clear definition. But what I would point to is so the regulations talk about family member substitutes, and they talk about the sort of the relationship. So I think you'd have to look at the relationship. If this person in the hypothetical you're giving is providing the type of role as a stepfather, then I think you could probably apply Factor 7 as an intrafamilial victim. If, for instance, you know, they're just there and maybe the child is older and the person isn't providing the type of support that you would think of a father-type figure, then maybe it would be reasonable under those circumstances to say the victim was extrafamilial, assuming it's the 2 years. So that's sort of a gray area left in terms of the definition of the regulations. But I think in this case, again, when you look at family member substitutes and you look at living in the home, that evidence was just not here. It was pretty clear from the evidence that he wasn't living with them full time. And then that takes me to the 2-year point, where the mother described that she had been dating the offender for a total of 2 years. So it's certainly possible or conceivable that they moved in together right at the beginning of the relationship, but I think that's probably unlikely. I think, you know, common sense tells us that most people don't move in together right away, especially when we have this other evidence about him maintaining a residence in Dorchester. But what the regulations say also is that it's 2 years from the offending behavior. And so let's assume that they did move in right away after those 2 years, which I'm not suggesting that the evidence supports. But even if you assume that, the victim reported that he had started coming into her bedroom a few months before the governing offense, and that he had began touching her. That was supported by what the father reported to DCF. I think it's also consistent with the evidence where the mother told DCF that she had told the offender not to touch her daughter, which is kind of a weird statement of why would you tell your boyfriend not to touch your daughter. But I think that makes sense with a few months prior, the father is told this by the victim, the father tells the mother, and he tells DCF that he told the mother this, and so that prompts the mother to say to the offender, hey, don't touch my daughter. So there's certainly evidence to support that this behavior had started a few months prior to the governing offense for which he was convicted. So even assuming that they moved in together right from the 2-year mark, that still falls short of 2 years when the offending began. And that's what the hearing examiner concludes in her findings. So it's the board's position that the hearing examiner's findings are entitled to deference here, as they were reasonable, they were supported based on the evidence, and that Factor 7 should be applied as an extrafamilial victim. In terms of the argument about harmless error, I'm not conceding that it was error, but even if the court were to find that it was error, that the hearing examiner applied Factor 7 in terms of the extrafamilial victim, there's still other evidence, as Justice Wood pointed out, or other factors that support the Level 2 classification. First, Factor 7, having an extrafamilial victim, that only applies to risk of reoffense. So if you take that out of the equation, the only analysis that's affected is the risk of reoffense analysis, not the degree of danger. So all the factors that the hearing examiner applied in terms of degree of danger are still at play, even if you find that Factor 7, she should have determined that the nature of the relationship was intrafamilial. But in terms of the risk of reoffense, first and foremost, we have Factor 3. Now, as the court knows, the board's analysis is supposed to be a qualitative, not a quantitative analysis, right? So I can't say that Factor 3 has so much more weight or give you a mathematical analysis of how much more weight Factor 3 should have than the other factors. But Factor 3 is delineated as a high-risk factor. Then there's risk-elevating factors. So Factor 3 really has to weigh more than some of the other factors here because it is delineated as a high-risk factor. So you have that, the fact that the offense was on an 11-year-old child. So that alone dictates a higher risk of reoffense than someone who offends against an adult. Then on top of that, you have the Factor 16 issue, the public place. And Attorney Hahn suggested that the research isn't robust, but there's research to support this factor. It's a factor that's in the board's regulations. It has not been overturned. It is supported by research that's cited in the factor. And it says that someone who offends when someone else is present, or that offends when they're likely to get caught, that shows a lack of impulse control. And that lack of impulse control, research shows, correlates to a higher risk of reoffense. So you have those factors at play, suggesting that he is at a higher risk to reoffend than someone who doesn't have those factors at play. So even if we were to take Factor 7 out of the analysis, it's the board's position that the Level 2 classification is still supported by clear and convincing evidence in this case.
And if there are no further questions, I will rest on my brief.
Thank you very much. The case is submitted. We'll take it under advisement. Thank you both for your arguments. So my understanding is that on the fifth case on the list, we were waiting for counsel for one side, and we have not yet had any input from. All right. So this, I understand, is Attorney Odununkwe, who was contacted by the clerk's office. The docket reflects was available for oral argument today, has not appeared and has not responded. I will ask for patience if we have our sixth case ready to go forward on the fifth case. If you wouldn't mind just standing back to see if we can, if there's a late appearance by Attorney Odununkwe. So I will call out of order the sixth case on the list, Melissa CAHL versus Brian Kenneth Wells. Just one. Okay, go ahead.
If it may please the court, Brian Wells on behalf of myself. This case is about not receiving notice, the default entered against me. I had no notice of the case. I didn't have notice of the case because service wasn't effectuated properly.
Attorney Wells, I have some questions for you just to try and get an understanding of what the landscape is here. First of all, what are the specific rulings that you believe you have correctly preserved on appeal for us today?
I have appealed the judgment, or excuse me.
The interlocutory decree?
Interlocutory decree. The rule, my motion to vacate that.
That was a Rule 12 motion to dismiss?
And the Rule 12 motion to dismiss on subject matter jurisdiction.
I'm sorry, were those two different things? I shouldn't have interrupted you, but I did.
Essentially, it's the Rule 60 motion to vacate, which is the interlocutory order itself, and the Rule 12 on subject matter jurisdiction.
Which was the Rule 60 motion?
60, excuse me, 60.
What was the Rule 60 motion?
Motion to vacate the interim decree for lack of notice. And essentially, though, everything would be wiped out because that's the law. I didn't have notice. Everything, they just got a final order without me. And this case is kind of, I just want to, sorry, excuse me.
No, go ahead.
The interlocutory decree entered in July, and after, with the partition statute, it's sort of, the execution happens, it's longer, and after that. And I know that there's been argument made that it's an interlocutory order. It's a decree, first of all, not an order. It's a little different.
Right, assuming that's a final judgment.
Yeah, it's a
There is,
final
as far as
judgment.
I can see, there was no notice of appeal that was ever filed with respect to the interlocutory decree. Am I mistaken about that?
I think that I'm asking for it to be vacated. So it's, yes, I mean, I want it to be vacated because it's issued without any hearings. I mean, I was there and already issued.
And with respect to, I'm sorry, I didn't mean to interrupt you.
So I of course want it vacated. It should. It
Understood, but my question is specifically about a notice of appeal.
The notice of appeal, I generally did what you always do on a notice of appeal. I noticed the general motions and preserved all rights for others.
Do you have a record cite for that?
What is it?
Do you have a record cite for your, whatever you're calling the equivalent of a notice of appeal?
The rules of appellate procedure state that the notice of appeal and those technicalities aren't driving.
Right, but where in the record is the document? The rules of appellate procedure require you to file a document that is a notice, considered a notice of appeal. Is there a record citation you can give us for your notice of appeal that you filed with regard to the decree?
Off the top of my head, I can't give it up. I don't know where it's in my appendix. However, I filed two notices of appeals, and I filed the same argument that Rule 60 It was under Rule 60. That's the only option I had. I thought it would be the trial court. I thought, it came in right after I learned of the decision.
When did you first become aware of the petition to partition?
In August 2020, I guess, 3.
Did you receive any of the copies of the citations that were purportedly left for you at 144 Willis Road in 2023?
No.
Did anyone besides you live at 144 Willis Road in May of 2023?
No, and we don't even know if they were delivered. There's no constable on record.
I think the question is whether you received them.
I said no. I said no. I said no. Excuse me if you didn't hear me. I did answer that. And I'm just saying that we had no way to, there's no...
How did you first learn of the existence of the petition, the partition petition?
Mr. Tracy sent me an email threatening to evict me out of my house, and that's how I noticed. And when I saw it, I responded. I first went to mass courts. There's nothing on there in mass courts. I couldn't find it in the papers. It's very weird. Then I just went to the probate court and was there and filed.
Did you include that email in your record appendix? I looked hard for that email, and I couldn't find that email. I found your declaration.
What email?
The email in which you say that Attorney Tracy threatened to evict you from the house.
Well, he served a motion to evict me.
Is that in the record?
I might have characterized that as a threat. That's in the docket. That's in the docket report, and it was filed on August 20-something, or in August. I could give you the exact date it was filed. But it was late August he filed that.
And that's how you learned about it?
That's how I learned about it, yes.
I'm unclear from the documents in the record and from your briefing what your position is on the judge's action with respect to your original motion to vacate. There are some cases in which it appears that you say that the judge never acted on it. Then at another point you argue that the judge constructively denied that. I'm not sure what your position is.
Sure. So the judge didn't act upon it, but she acted on other things. And that, to me, was she acted on having the partition sale go forward. And that was, to me, a constructive denial, because if they're going to go forward with the partition that I'm trying to vacate, once the partition is executed, I don't really have an appeal. It's too late. So that's what I meant by constructive, that constructively she denied relief. She was going forward to appointing the commissioner, having there's an auction scheduled, doing all those steps after I had sought to appeal, or sought to vacate. And to me, that's if you're going to go forward with the case, sometimes, it's kind of obvious that it was denied.
I see your argument there. You pick a date for that constructive denial as October 28th of 2023. What is the significance of that date? Why is that the constructive denial date, based on what you've just told us?
That was the date of the order that entered. And the probate court here often didn't, the dates they entered it into the docket and wrote the order were much farther apart than usual. So October 28th was the date, I believe, on the order itself. And it might have not entered until late November.
Yeah, I think you're right about that.
So that's why I considered it October 28th
But it wasn't action on it was a constructive denial, but what motions were acted on that day that you say resulted in the constructive denial of your motion to vacate?
Well, on that day, she also struck a motion for preliminary injunction, which for basically the fact that it was too late because judgment had already entered. She didn't issue any reasoned opinions. That as well. There's a few orders on 28th. There's a slew of
motion for specific performance, I think. I think
That's
she
right.
denied, you filed three.
She struck them from the record.
Okay, but so you're saying on the date that she either struck or denied, I take the day that she struck the motion for preliminary injunction and the date that she struck the motion for specific performance, you're saying she effectively ruled on the motion to vacate.
That's another instance, right? especially with the extent of striking it. Because striking it says, hey, there's a judgment here, sorry. We're not going to consider it, we're striking it.
But that's the reason you use that date, I think, is that, I'm understanding you to say, that's why you pick October 28, 2023, because she ruled on the other motions which you filed on the same date as the motion to vacate, is that right?
I filed on the same date as this?
Yeah, you filed the motion to vacate, right? You also filed a motion for preliminary injunction, and you filed a motion for specific performance, right?
That's right, that's right.
And
I believe
she ruled on 2 of those 3 on October 28, around October 28, 2023.
Right.
Right, and you're saying that that's the date that she constructively denied your motion to vacate?
Right. Okay. That's, when those were denied, that was constructive. The striking the motion of seeking specific performance, for instance, I might have filed that a couple days after.
Okay.
That was another reason it's kind of struck. That was different than denying it, because if you deny it, it might be considered, but it was struck because it was, judgment had already entered. And that sort of, she was going forward, she appointed a commissioner. The commissioner had charges, she lifted the stay. I mean, the case was going forward, they're trying to sell my house. So, I thought filing notice of appeal was prudent. And I also don't want to, I tried, in May, you see it in the briefs that I did try to file, I filed a few emergency briefs for the appraisal or the auction not to go forward because it just cost money and it was a waste, I think. I think it's really, I never received notice. If you look at the papers, we don't know who the constable is. Under pains of penalty of perjury, said that this happened, it didn't. Said there's a constable, there isn't. Said that there's, got the motion for notice on false statements, which I think is, it doesn't matter. There's just no following of Rule 4, and I had no notice. I mean, that's the end of the story. And this statute requires an interested party be served in this situation. I mean, the statute really protects people's homes, It's not like, oh, sorry, you're a couple days late, default judgment, you're going to lose hundreds of thousands of dollars. We got you, we tricked you. I mean, that's what happened here. You have all these papers, but the person under Rule 4 wasn't, nobody under Rule 4, we don't have any testimony. And the person should have came and testified. I had the right, that's his burden, not my burden to prove service, it's his burden.
Could I interrupt you and ask a couple of questions, just because time is short?
Yeah.
My understanding is that one of the things that you're appealing from what you told us earlier this morning is the denial of your Rule 12 motion. You've referred a couple of times to a Rule 60 motion. I don't see any reference to Rule 60 in any of the motions that rulings that you're appealing. Am I missing it? Is there a reference to either Rule 60 or Rule 55 anywhere in those?
I'm certain there is, and it might not have said it on the...
Can you tell me where?
What is it?
Can you tell me where?
Probably in the, I can't say exactly the spot right here, but there are motions to vacate judgment, which is Rule 60, and I would cite that under the rules usually.
Okay.
So I can give you the letter, I can write a letter and tell you exactly where it is after, if it please the court.
We have the record. I just was hopeful that you could tell me where I could find it in there, but I understand your answer. And can you tell me, if you're relying on Rule 12, do you have any authority that would tell us how Rule 12 can be used to attack an interlocutory decree like the one at issue here?
So that's a great question, and so it's subject matter jurisdiction. So I wasn't sure, and there was nothing on point here, whether it's subject matter jurisdiction under Rule 12, which always is considered, even on appellate stage, subject matter jurisdiction, would be required to be brought on appeal for a motion to dismiss based on a default judgment. So to be safe, I included the argument. It wasn't considered, it was just kind of blanket denied. And whether or not, I guess if judgment's not vacated, do you still have to consider subject matter? I suppose you would, but maybe not. It's a good question. I'm not sure. I just know that a week before this petition was filed, 3 months before this petition was filed, we had an agreement. And basically, what happened is, and I'd like, if you want to take judicial notice of Colby Wells, the probate Court, I believe it's I can even send the docket. She filed a paternity act against me, and that was dismissed because she wouldn't take a paternity test. I know the brief really talked about me being a bad person and all of that, and this is just a continued fraud. A week after that happened, she filed this, even though I had an agreement. And in the papers, he does not recognize that. The fact of the matter is the fraud has been going on for a few years. And this is just continuing the fraud. And a very, very difficult fraud in terms of having, I don't know, it's a tough loss. And I can get I'll get the docket. I have it right here, just so you can take just some notice of it. Final judgment already entered.
We have the docket.
Oh, it's
Attorney Wells.
22W 1928. You have that? Okay. And this went against the agreement that we had, and it's been, a year and a half, almost 2 years of just a waste of time. And, I've been fair. I don't, it's just really, yeah, you don't take this much property away from somebody. You don't steal somebody's property without notice. I mean, that's just the Constitution. Thank you, Your Honor.
Thank you very much. Counsel.
Good afternoon, Your Honors. Joshua Tracy on behalf of the appellee, Melissa CAHL. The issues before the court generally are whether Mr. Wells' appeal should be dismissed and denied on account of his repeated and pervasive failures to comply with the rules of procedure, rules of appellate procedure.
We drill down on a notice, personal service. Is personal service, he makes the argument, citing Kimball, a 19th century case, that personal service is necessary. I don't think that's right. What is your citation to, I think that in fact under Mass Civil Procedure Rule 4D1, it's adequate if it's left, a copy is left at his last and usual place of abode. Have I got that right?
That is exactly correct, Your Honor.
Right. And the record citation, I think that we have a process server, you included in your record appendix, indicates that he did precisely that.
Correct.
Okay. So that's the notice that you're hanging your hat on, right?
In part.
In part, right.
So
But let's just say, first of all, that would be adequate by itself.
Correct. In accordance with the citation issued by the court on, yes.
Right. Thank you.
The court citation required that the citation and petition to partition be delivered. That was the word used, delivered to Mr. Wells. And if it could not be delivered, then it was to be mailed to him. He was served. Brad Merring, the process server, left it at his last and usual place of abode. He signed an affidavit. I filled out the bottom of the citation, declaring under the penalties of perjury that that's what occurred. I attached to it Mr. Merring's statement signed under the penalties of perjury. I completed a separate affidavit as well, explaining in detail exactly what had happened.
Sorry, one question. Mr. Merring's status as a process server versus a constable or a special process server, do you concede that Mr. Merring was not authorized by statute to serve this process?
I can't concede that point. I will say that he was not a constable. He was not a deputy sheriff. But I did get permission from the court, and I did get approval from the court to allow the service to occur the way it did. I specifically filed a motion to accept services as rendered.
I see. So post.
Correct.
hoc. So that's rather, am I understanding correctly that your position is, although you did not seek to have Mr. Merring identified as a special process server by court order, you made that request retroactively?
Correct.
Gotcha. Okay. Thank you. I'm sorry to interrupt you.
Okay. No, not at all. Your opponent, or Mr. Wells, makes this point or claims that it's required under that service be, if it's going to be by mail, it be by registered certified mail. Do you dispute that as a matter of law?
Forgive me, Justice Wood, I'm not sure I understand the question.
I think that Mr. Wells claims that the service had to be either in hand, we've discussed that already, or by registered or certified mail. And I think your response is your process server left it at his last and usual place of abode, and you sent it to him by U.S. mail.
Correct.
Right.
And I'm saying that that is sufficient within the terms and the order of the court pursuant to that citation and Rule 4D of the Rules of Civil Procedure, last and usual place of abode. Right. And in addition to that, he was on notice by virtue of the publication in the Gardner News as required by the court. He was on notice by virtue of the filing of an affidavit in the Registry of Deeds, putting him on notice and putting the world on notice. More importantly, not only was he told in negotiations over the potential buyout of my client's interest in the house that a petition to partition would be filed in the event the negotiations failed, and they did. But after the petition to partition was filed, after he was served, after it was publicized, at the end of June, I emailed Mr. Wells, and that's part of the record, and I asked him to avoid bearing the cost of a commissioner, could we agree to stipulate to sell the property by private sale? Didn't hear from him. That was by email. About a week or so later, I filed a motion to appoint a commissioner. I served it on him by first-class mail and email. And I marked it up for hearing on July 13th, and I gave him notice by that motion. Never heard from him. On July 13th, I emailed Mr. Wells again, and I explained that the hearing was off because the court called me and said, because there was no appearance or objection to the petition to partition, the court was going to appoint sua sponte a commissioner. So the hearing was off. So that's what I notified him. So he knew as early as July 13th, forgive me, at the end of June, that there was a petition to partition. He knew in July,
right.
Before an interlocutory decree issued.
I'm aware of the record. Can I ask, and I appreciate that that's my understanding of the record as well, can I, a slightly more conceptual question, if we were to accept that he didn't actually get, all of that is to describe he had actual notice. The negotiations before break down, we'll see you in court, the final email, meaning we're going to file the petition, that's part of his notice, and then these emails afterwards, we're going to be moving forward with the commissioner, that's actual notice. All of this together is actual notice that we will and then have filed a petition. Can you give me your best case that by itself, that I know that's not actually your argument, that it's by itself, but that actual notice suffices? Is there a case that establishes that, in other words, actual notice is sufficient to establish notice?
I think arguably that might be constructive notice.
Sorry, thank you. Thank you.
Because he would say he wasn't served in hand.
Right.
So I guess the question is whether those other types of service, that other type of notice is sufficient to make up the legal notice. I would suggest yes, and the reason why is.
But sir, more than suggest, I mean, the best answer would be, here's a case that says that.
Unfortunately, I don't have one, and I did research. I wasn't able to put my hands on one.
Okay.
The cases that he has cited do not stand for the propositions for which he offered. And due to time constraints in the brief, I just couldn't get into it. But if the court were to review the four cases he cites, Lally versus Dorchester, Williams versus Kimball, Law Office of Alfred Farisi versus Florida, those cases do not stand for the proposition that it needs to be in hand. And that if a constable or someone not authorized to serve, that rendered the service deficient. None of those cases stand for that proposition.
Right, but your affirmative case
I don't have an affirmative case, Your Honor, yes. I don't have an affirmative case that says constructive notice is enough. I've relied on what the citation required, and I relied on, and I feel that I've complied with it under the law, and I believe the judge approved it. And I think I've satisfied the statute. If the court was concerned, if the trial court was concerned, presumably, the trial court would have directed me to accomplish additional service to ensure he was notified. Critically, there was talk during Mr. Wells' argument about the motion when he first learned of the petition to partition. He said August. In fact, it was August 23rd. And this is in my record. I filed it in the supplemental record appendix. I filed a motion for leave to allow my client to enter the locus, the property, to get her personal property. And I filed a motion asking for a court order directing Mr. Wells to vacate because the commissioner needed to be able to get into the property with a broker to list the property for sale. I served those by email and first-class mail. That triggered Mr. Wells filing a few motions. A motion for preliminary injunction, a motion for specific performance, and his motion to vacate under Rule 12.
Sorry, what's the legal significance of that, though, other than, right, sorry, go ahead. What's the legal significance?
The legal significance, if he had an opportunity, he was on notice at that point, he could have filed a motion for leave to file a notice of appeal late. All right? So the interlocutory decree entered July 21st on the docket. He had until August 21st to file a notice of appeal. On August 23rd, I served those motions. He's admitted here today that he received them. He could have filed a motion for leave to file a notice of appeal late and preserved his appellate rights.
Right, so I just want to nail this down. The order, the decree, he had what, 30 days to file a notice of appeal, and that 30 days expired on August 21st. You just said
correct.
And he, accepting your representation that he learned on August 23rd that you're filing a motion to vacate the locus so your client can get her property, he could have at that point filed a motion for leave to file a notice of appeal late, which would have been 2 days late. That's your point.
Correct.
Right.
Absolutely.
Right.
And the trial court had discretion to extend that period for 30 days beyond August 21st.
Right.
And that's it. But he didn't do that. Instead, he took a different tack. And I think what this shows is Mr. Wells, and I think my brief bears this out with his failure to comply with the rules of procedure, the rules of appellate procedure, excuse me. Notwithstanding the fact that he's an attorney, he appears to be ignorant of the law, ignorant of the rules of procedure, ignorant of petitions to partition law, and fails repeatedly to comply with his obligations. That's pervasive throughout this case. He didn't comply with the rules of procedure, as my brief explains, with respect to giving my client an opportunity to participate in the assembly of the record appendix. He didn't notify within 14 days of filing his appeal the statement of the issues that were going to be presented on appeal, what was going to be included as part of the record appendix. It goes on and on and on. And he didn't file his supplemental notice of appeal on time with respect to his renewed motion to dismiss. So recall that he filed a renewed motion to dismiss in May of 2024, and it was heard at the end of May. The court issued a ruling at the end of June, I think June 26, 2024. It entered on the docket June 26, 2024. He filed a supplemental notice of appeal denying that renewed motion to dismiss on August 5th. It was late. Throughout my brief, I don't want to waste the court's time. My brief goes through it in copious detail. But time after time and time after time again, he just fails to comply with the rules of procedure, ignores his responsibilities under the law. He's an attorney. Even if he were pro se, that's no excuse. But he's an attorney. He's a litigator. He holds himself out as a litigator. He should know, and he was on notice. And I think that the court should look at Mr. Wells' claim with a jaundiced eye when he says he didn't know, he didn't get notice of it. When Mr. Mary mailed the petition to partition to him, in addition to leaving it at his last and usual place of abode, that mail never made it back to Mr. Mary, and he would have told me. Whenever I mailed anything to Mr. Wells, it would have made its way back to me if it didn't go to him. I never got anything back. This is all in my brief. If your honors don't have any other questions, I'm content to rest on my brief, which I think is very, very detailed and sets forth.
All right, thank you. Thank you
Thank you
both
very
very
much.
much. Matters submitted, and we have it under advisement. All right, and with thanks for council's patience for the change in order, the next matter in our final case for today is Josh Anaosa versus Copart of Connecticut, Incorporated 2024 P0821. As we indicated earlier, this matter was on as our fifth case. The case was prepared to be called in order. Counsel Attorney Odunkwe was not present. The docket reflects that he was available for oral argument today. I understand from our court officers that the clerk's office here has tried to reach that attorney, has been unsuccessful in doing that, and the attorney has not checked in. Any further information?
Yes, he did call.
Okay.
He didn't get it until he got about the case. He's hearing today. He will send something in writing, asking to have it rescheduled. He cannot do that.
Understanding that that is the presence, that's the position that counsel takes today, what is your position? Is it Attorney Hutchinson?
Yes, sir.
What's your position, sir?
Your Honor, I don't object to rescheduling, but it's cost my client a lot of money to have him sit here all morning. So considering that he just forgot about it, it doesn't even be that he suffered any type of unexpected event that prevented him from being here. I think the continuation, but he should be assessed my attorney's fees associates here, so that this hasn't been a burden on my client for his mismanagement.
Would you bear with me for 5 minutes while I step off and speak with my panel?
All rise. Brief recess.
Right, thank you again for your patience. The panel has agreed that we will go forward with your oral argument here today. We'll make further orders as necessary under Mass RAP 22 concerning the availability of a brief written submission by opposing counsel after argument to respond to the points that you have raised at your argument. But at this point, again, with appreciation for your patience, we'll go forward. If you would just wait for the recording to begin. And again, we're calling Josh ANYAOSAH versus Copart of Connecticut, Inc., 2024 P0821.
Good afternoon, Your Honor. I'm Warren Hutchison, representing the appellant, Copart of Connecticut, Inc., and we come before this court seeking a ruling that the District Court Appellate Division's dismissal of the appeal as interlocutory was error, and asking this court to reverse the trial court judge's decision, which was entered sua sponte, without notice, and after the time for a valid appeal had expired, reversing himself on a prior order dismissing the case, and we seek an order remanding the case and ordering it be dismissed.
So am I correct that there's no binding authority on us here?
There's no binding Massachusetts authority. That's right.
Okay. So how can we find that the trial judge and then the appellate division abused their discretion here? Or what is the correct standard of review?
It's not abuse of discretion because the cognate federal rule has been interpreted by at least 6 circuits. 3 of those circuits say you need a motion because the rule says upon motion. And this court can rule.
Does it have to be a written motion or can it be an oral motion?
I'm not prepared to say, but that wasn't the point. I mean, that didn't exist in this case. There was never a motion, written or oral, by this plaintiff that the prior decision be reconsidered. In fact, plaintiff instead simply doubled down on the concept that he had filed an appropriate appeal to referencing the wrong rules and ignoring all of the criteria and all of the appellate requirements to perfect an appeal before the District Court Appellate Division.
Right, but this arose after a hearing in, I think it was October. There was a hearing on purportedly on your motion to dismiss his appeal, right?
Correct.
There was an actual hearing, right?
There's an actual hearing.
After that hearing, the judge issued this sua sponte ruling on a Rule 60B, right?
Well, he actually rolled from the bench. He simply said from the bench.
Okay, and all right, so where is that transcript? Is it in, let me restate, is it in the record? Is that transcript in the record?
It's not in the record, Your Honor.
Okay, isn't that crucial for our evaluation of the judge's decision?
I submit it as not, because the judge then docketed that he was simply reversing his prior order, which he did not have any authority to do. And they didn't say anything more in the, during the hearing on the bench other than I made a mistake, and so I'm reversing myself, and I'm sending this case down for discovery.
Was there any argument before that, on that date?
I believe I did make the argument that the appeal should be dismissed because of all the reasons we've given in our brief here and before every court that we've been in front of. And again, the opposition, there was an opposition that again, not that he had to comply with the District Court rules of appellate procedure, but simply that he'd otherwise perfected his appeal.
Sorry, I think you just said there was an opposition. Do you mean he made an oral opposition in that hearing?
He made a written opposition and an oral opposition.
Okay, so what I'm hearing now is you believe you argued I'm not trying to misrepresent, I'm just trying to understand it because we don't have the transcript. You believe you made an argument on your motion to dismiss, and you believe he made an oral argument in response to your motion to dismiss. Is that right?
Correct.
Okay, and then the judge, you believe, well, not you believe, clearly said, forget all that, I made a mistake, I'm going to sua sponte under Rule 60B, vacate and remand for further, or order further
Except
discovery.
there was no reference to 60B.
Oh, okay.
Okay, there was no reference whatsoever to 60B. He just simply said, I made a mistake, and I'm undoing my prior order.
Okay.
Shouldn't we want to encourage trial judges to do that if they think they made a mistake, rather than have the parties go forward with an appeal that the judge no longer thinks is correct?
Not if, certainly you could encourage that if the appeal period hasn't expired and the court gives the parties notice that he's going to do that, so that an appropriate argument preparation can be made by someone in my position as the opponent, and we can present that to the court. But there was no notice given that he was about to do that. Again, the appeal period at that point had expired. So he was essentially throwing the plaintiff a lifeline. He had my motion in front of him. He realized that the appeal had expired, and he says, I'm going to help this guy out, so I'm going to just reverse my prior decision.
Okay, he did that, I hear you. He did that on the record at that hearing?
Well, the result was, that's what was his result. He didn't verbalize that he was helping them out.
No. But sorry, I didn't mean to suggest that. Right. But I think you said previous. I'm not trying to trick you. I'm just trying to understand again the transcript, which we don't have. That the judge made clear orally, I am reversing my previous order.
Correct.
Right. So why didn't you at that point raise the notice problem, or did you? Did you raise the notice problem at that point?
I did not, because I didn't think that he had, quite frankly, any authority to do that. He wasn't citing Rule 60B, and if I had done the research on Rule 60B at that point and what the law was, I wouldn't have argued notice. I would have argued, Your Honor, first of all, there's no motion in front of you, and you don't have authority in any event because the appeal is expired.
Okay, but
so notice wouldn't have cured anything.
Okay.
What about your motion to dismiss the appeal? Couldn't that be what is the upon motion in 60B?
No, because it's upon motion. Again, it wasn't my motion for him to reconsider. This has to be the motion to reconsider. So it wasn't my motion for him to reconsider his prior decision. And so
you're saying it has to be a motion to reconsider under 60B. It can't be some other kind of motion.
Exactly, Your Honor.
Right, but back to the point of authority, you said at some point we have 6 federal court decisions. My understanding of...
Well, there may be more than 6, but there are 6 circuits that have addressed it.
Right, but is it fair to say that the circuits are split on this question?
They're only split on the question of whether you need a motion.
Right.
Okay?
Okay.
But they're not split on those who say a judge can order sua sponte, basically Rule 60B relief. They all say, but he cannot do so, or she cannot do so, if either no notice has been given to the parties or the time for an appeal has expired. Because Rule 60B also says it has to be made within a reasonable time, and they've all interpreted reasonable time as the time for an appeal hasn't expired for this very reason. And Eaton is a case that talks about it directly, and others, that we don't want judges to be essentially curing appellate defects.
Okay, but sorry,
60B.
Right. I hear you. I'm sorry to cut you off, but this, in fact, it's a little more complicated than that. The plaintiff's counsel did file a notice of appeal. What you're saying is, and he, for whatever reason, it seems, it would be nice if we had him here, but that he believed that the Massachusetts Rules of Appellate Procedure applied, and he complied with those rules. Your point is he didn't comply with the district court appellate division rules of appellate procedure, and specifically identify what he was appealing more pursuant to those rules, right?
Correct.
Okay, but so he did actually express an intent to appeal the judge's original, he expressed an intent to appeal, period.
Expressed an intent to appeal, but that wasn't good enough. And he could have expressed an intent to appeal using the Wyoming rules of appellate procedure or the AAA rules of appeal of arbitrations. This court and those rules had no application to that appeal. And by him simply reciting the fact that I intend to appeal, that would be a nice first step, but the rules of a district court appellate procedure specifically require, and the courts say that if you don't meet those criteria, your appeal is a nullity. That includes identifying the issues, paying your fee, et cetera. So his argument, and he relies on it in his brief before this court, and he relied on his brief in the court below, that somehow he was saved by the rules of appellate procedure. That is not the case, because those rules did not apply to him any more than the rules, again, of some other states.
I've got it. But let's assume, for the sake of argument, that we have some discretion to allow some loosening of the rules of appellate procedure, at least in this context, that allows us to get underneath, and perhaps based on the equities of the matter. Your client could have avoided all of this by giving the plaintiff a refund when it was discovered that the car didn't run. And what do you say about that?
Well, that's always the case, that you can capitulate to a party.
Capitulate. Sorry, why would that? Let me rephrase it. Why would it have not been reasonable and equitable to give the plaintiff a refund for a car that didn't run?
Because they told him it did not run. He was an experienced, unlike what he characterizes himself in his brief. He had purchased 50 other cars through this auction site before.
Is that in the record?
That's in the record. It's in a footnote in the brief.
That's fine. I'll find it if it's in there.
That's Record Appendix 420. We have it in a footnote before the prior, which is something that my client, quite frankly, only sort of discovered as preparing the discovery responses in this thing, and it came. But essentially, he purchased 50 cars over the last year and almost $250,000 worth of automobiles through this website, and he was no neophyte nurse struggling to buy a car and that he was going to use on his own. This was a business for him, and my client can't be in the position of making exceptions to people. They have, quite frankly, a very generous policy that says, if there's anything about the car that you don't like, when you come and pick it up, just tell us, but don't take it away, just tell us and we'll refund your money. Or if there's something that you can't see and it makes a material difference to you and you don't know about, then we'll refund. But it specifically says, if it's visible to you and you know about it, otherwise know about it, and you come and pick it up and you take it off the lot, that's it, the deal's done. And that's a reasonable policy to have in a situation like this, where they're selling to people potentially all over the country, all over the world potentially, and they can't be making these accommodations every time someone is not satisfied, even though they were told, this car doesn't run. Do you want to reverse the transaction? He says, no, I'm going to come and pick it up.
I mean, we all know the facts, that he was told it didn't run was in a single email,
right,
that was contradicting the representation in the online advertisement, which included, as I understand it, among other things, a video of the car that was purportedly for sale running.
Right.
And so it seems the record supports the inference that he was given a different car, which was the same model, I guess.
No.
No?
No, Your Honor, I don't think there's no evidence of that.
How do we get from a video of the car running to the car not
running? It's not
running?
my client's video, Your Honor. Again, they're sort of an auctioneer. So if you think of the old type auctions, the auctioneer stands up and people parade cars in front of him, and he sells the car. He doesn't know what that car is. He doesn't know where it came from. And my client, these aren't cars that my client owns. These are cars from third parties that offer them to my client to sell, and they sell them, and the information comes from those third parties. So again, the policy is that he signs off on, his terms and conditions say that if there's some misrepresentation in here that you're not aware about, before you take the car off the lot, and you take it off and then you find out about it, you can get reimbursed. But if you know about it, if it's visible to your eyes, you see it and you take it off the lot, the car's yours. We're not going to reverse a sale under that condition. And they not only told him it didn't run, they said, unlike the advertisement, this car does not run. So that was in the email. So they were being as honest as they could with him. And he decided that he was going to take the car anyway. And so he's bound by those terms and conditions in his contract, including something that's been completely avoided here, that those terms and conditions require this case to be brought in Connecticut. And he agreed to that. So we shouldn't even be in the courts of this Commonwealth. The district court judge simply ignored that. The appellate division ignored that. And basically, he was given a lifeline by the district court judge after the appeal period had ended to drag my client through litigation in the Massachusetts courts that he agreed wouldn't even happen. So I submit, Your Honor, and one point we didn't make on our brief, but I think is
We do have to call time on this.
Okay, I have
counsel,
21
so
seconds, I think, right?
I'll give you
So the
a very short time.
The appellate division decision essentially acknowledged that he did not file a valid appeal because, interestingly, the court said we cannot use Rule 60B, or a trial judge can't use Rule 60B to resurrect a case where the appeal had expired. And the court said there, quite frankly, confoundingly, they said, well, but he didn't file a motion under Rule 60B. The judge simply acted on his own. So the appellate division made this basically illogical conclusion that if he had filed a motion under Rule 60B at the time that we filed our motion to dismiss, he would have necessarily had to have been denied because the time for appeal had expired. But because he didn't file a motion, somehow the judge accepted this inherent power of the courts, relying on federal precedent that didn't even support what they said, and in fact was contrary to everything that the court did.
Thank you very much. We appreciate your argument. I very much appreciate your patience. And we will issue a further order under Rule 22 in short order.
Yeah, thank you.
And that concludes our sitting for today. I'd like to thank the clerks, the court officers, and the clerk's office for making today's sitting possible. Thank you.
Yours are ready. My friend, nice to see you.